asked you to move it up if you can. Oh my, you should be here by 4. You shouldn't even be here by 4, what's it? Yeah. Which choice do I make?
Why can't you be here with Trump on the
The God's ear. Thanks, man. Oh, Ling Ha, she's the applicant. Probably, I don't know, 70.
Got a special copy. Mine's autographed. Yeah. You're making me sweat.
Let me pour it out of a pile and put it in my consent pile.
Ready when you are.
Okay, good afternoon. We'll come to order. Good afternoon and welcome to the Tuesday, the March 28th, 2017 convening of the Baltimore City Board of Municipal and Zoning Appeals. A couple of house rules before we get underway. First, if you have a cell phone, a pager, anything that plays a ringtone or any other audible, electronically generated sound, we ask at a minimum you please turn those devices to a vibrate only if not off position. Similarly, to the extent that you need to have a conversation with your neighbor, we ask that you please take that conversation out the double doors to your rear. And the reason for those rules is pretty simple and straightforward. You'll note that there are a number of microphones which are arrayed around us up here, and those microphones are all very sensitive, not only for the purpose of amplification, but they're also for the purpose of recording. And cell phones, pagers, and the like, besides being generally disruptive to the conduct of these proceedings, also interrupt the recording of those proceedings as well. Additionally, those of you who are forward of the wall above you, if you turn, you can see that there are 1, 2, 3 video cameras which are mounted on the wall back there behind you. There are 1, 2 video cameras which are mounted on the wall up here behind us. These proceedings are also being taped for broadcast via streaming on the city's cable access network, as well as for the city's I guess the cable access website. It was streaming there, and we broadcast on the cable access network, and also saved for the city's YouTube channel. So telephones, pagers, and the conversations and the like also disrupt that process as well. You're more than able to stick around to find out how we rule at the end of the day. But if you've got other things to do with your afternoon, we certainly can understand. You can call into the zoning board office tomorrow morning and find out how we ruled in your case. If you take out pen and paper, I will read the number for the zoning board off a couple of times. That number is 410-396-4301. Again, that number is 410-396-4301. You will, however, need to wait until you receive the formal written notice of the outcome of your case, which should be forthcoming in about 3 to 4 weeks, before you'll be able to obtain all of your permits. Let me please ask that you not build in the city of Baltimore without first obtaining all of your proper permits. If you have not already done so, if you're here in opposition to any case, we ask that you please sign in on our sign-in sheet. It's being held up there by Mr. French. The sign-in sheet allows us generally to know which cases have opposition, but also allows us to know who needs to receive those aforementioned written notices I just talked about. Additionally, if your case is postponed or for any reason is not heard today, and we do have a couple of those on our docket for today, we need to know who you are and how to contact you to let you know when those cases will be going forward, as they will not be going forward today. If you are the appellant, the procedure when the cases are called is you'll come forward and you'll stand to our left or your right. The opposition, if any, will stand to our right or your left. Once everyone is up here, we'll get everyone sworn in, and first we'll begin with the appellant. We'll be given the opportunity to tell the board about what it is that they are proposing, present any documents or testimony in support of their arguments, and respond to any questions which the board may have. Once they've concluded with their presentation, we'll then hear from the opposition, who'll be given the opportunity to express their side of things, present their witnesses, documents, etc., in support of their position. Finally, we'll return back to the appellant, who'll be given the opportunity to respond to any points brought up by their opposition, if any, and then to offer a closing statement. We won't be going back and forth and necessarily delaying things any longer than is necessary. We'll generally be hearing the cases in the order in which they appear on our docket once we first dispense with some preliminary issues. First, as I said, that there are a few cases which have been postponed or withdrawn, and those cases will not be heard today. Those cases are 2015-500, 1213 Edmondson Avenue. That case has been postponed. And 2017 through 2017-86, 2027 Maryland Avenue. That case has been postponed until May 9th. And finally, 2017-88, 612 Springfield Avenue. That case has been withdrawn. Those cases will not be heard today, so if you are here in reference or any of those cases, we ask that you please make sure that you signed in our signing sheet so we can let you know when those cases which have been postponed will be heard. The next batch of cases which we're going to address are those which appear on our consent agenda. The consent agenda consists of cases where the zoning board staff has reviewed our files in these matters, and the board has determined that there's enough information to approve these appeals on a consent basis based on the record which has been submitted. We're going to call all the consent cases together as a group. So once I read the first one off, and then the one after that, and the one after that, everyone's going to line up in a line down here in front of the dais. Just please try to make sure that you stay in the order in which you're called. Once everyone is up here, we'll have you all sworn in as a group, and we'll call each case in turn, and you'll be given the opportunity then to submit any information you would like to have added to the record at that time. The first case on the consent agenda is 2016-451, 852 South Bond Street, Caroline Hecker. Next case is 2017-49, 802 South Lakewood Avenue, Matt Nofel. And after that will be 2017-55, 918 South Kenwood Avenue, Frank Frederico. Then will be 2017-56, 3400 Mueller Street, Dave Carey. Then 2017-59, 237 South Conkling Street, Nate Prettle. 2017-63, 710 East Eager Street, Tom Rice. And 2017-66, 261 South East Avenue, Travis Luckman. Then will be 2017-69, 309 South Duncan Street, Kareem Harid. 2017-76, 820 South Decker Street, Travis Lockman. Then 2017-77, 1920 Goff Street, Rich Poland. 2017-78, 2521 North Charles Street, William Shaughnessy. In 2017-79, 2100 Alisana Street, Lynn Ha. 2017-80, 1544 William Street, Jennifer Nardi. 2017-82, 409 South Register Street, John Cole. 2017-83, 707 South Glover Street, Matt Nofel. And finally, 2017-91, 6575 Eastern Avenue, Caroline Hecker. All right. If all those intending to give testimony can please raise their right hands and be sworn, please.
You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, calling the first case, 2016-451, 852 South Bond Street, Caroline Hecker.
Good morning, or good afternoon, Justin Williams on behalf of the applicant, Fatima Elkhan.
Afternoon, Mr. Williams. We have this as an application to use the premises for retail space, one dwelling unit and one efficiency unit. Is that correct?
Correct.
All right. Mr. French, anything on behalf of the planning department?
Thank you. Martin French for the Baltimore City Planning Department. Planning Department notes that this property is located in the Fells Point Historic District, and on that basis recommends that approval of this application be subject to the condition that all exterior changes, including additions, demolitions, alterations, and signage, are completed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you. And Mr. Williams, is that condition offered by the planning department acceptable to your client?
Yes.
All right. And do you have anything further you would like to have added to the record?
Packet of
this time?
exhibits with information to support our request. There's also a letter of support from the Fells Point Residents Association. There's one condition in the letter that requests there be no food service in the establishment. We would object to that condition. It's property zone B2, which permits food service by right, and we're only here for the multi-family conversion.
Okay. Anything else?
That's all.
Okay. Zoning board staff, having previously reviewed your application, we've determined that there is sufficient information to approve your appeal. Good luck. Are you handling the Eastern Avenue, or is that Ms.
I am.
Hecker? You are? Okay, I'll call that one. 2017-91, 6575 Eastern Avenue.
Good afternoon, Justin Williams, Rosemary Martin Greenberg. On behalf of the applicant, Eastern Animal Hospital, here with Dr. Jonathan Kaufman.
Afternoon. Mr. Williams, we have this an application to construct a two-story animal hospital with 65 parking spaces accessed from a private way. Is that correct?
Correct.
All right. Mr. French, anything for the planning department?
Planning Department notes this property is part of an area that was subject to a subdivision plan and development plan. Therefore, recommends approval of this application subject to the condition that the property is improved in accordance with the development plan that has been approved by the Planning Commission. Thank you.
Okay. And Mr. Williams, is that condition offered by the planning department acceptable to your client?
Yes.
All right. And is there anything further you would like to have added to the record at this time?
Pile of exhibits to support our appeal.
All right. Is that it?
Nothing further.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve the appeal.
Thank you.
Good luck. Take care. Next, 2017-49, 802 South Lakewood Avenue, Matt Nofel.
Good afternoon.
Afternoon, sir. We have this an application to construct a second floor, overhanging rear addition and rooftop deck at this location. Is that correct?
Correct.
All right. And Mr. French, is there anything from the planning department?
Planning Department has no comment on this application. Thank you.
All right. Mr. Nofel, anything further you would like to add to something the record in this case?
No, sir.
Okay. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
You got another one, right?
Yes, sir.
Yes, there it is. 2017-83, 707 South Glover Street, also Matt Nofel. And Mr. Nofel, we also have this as a application to construct a two-story rear addition with rooftop deck at this location. Is that correct?
Correct.
All right. Mr. French, anything from the planning department?
Planning Department has no comment on this application. Thank you.
All right. And Mr. Nofel, anything you'd like to add to something on the record in your case?
No, sir.
Zoning board staff, having previously reviewed the application, we have determined that there is sufficient reason to approve your appeal.
Thank you.
Good luck.
Good afternoon.
Thanks, you too. Next, 2017-55, 918 South Kenwood Avenue, Frank Federico.
Actually, Nick Lipperini.
Okay. And Mr. Lipperini, we have this as an application to construct a second-floor rear addition, new third floor, and rooftop deck at this location. Is that correct?
Correct.
All right. Ms. French, anything from the planning department?
Planning Department has no comment on this application. Thank you.
All right. And Mr. Lipperini, anything further you would like to have added to supplement the record?
No.
Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
Good luck. Next, 2017-56, 3400 Mueller Street, Dave Carey. All right, we'll skip that.
Mueller?
I'll skip that and go to 2017-59, 237 South Conklin Street, Nate Prettle.
Good afternoon.
Afternoon, Mr. Prettle. We have this application to use the premises as 2 dwelling units. Is that correct?
That's correct.
All right. Mr. French, anything for the planning department?
Planning Department reviewed this application and has no objection to approval. Thank you.
Okay. And Mr. Prettle, anything further you would like to have added to the record in your case?
Sure, I would just add that there should be a letter of support from the Highlandtown Community Association in your file. If there isn't, I will provide it. You got it? Very good.
Okay, we have that. Anything further?
That's it.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to appeal.
Thank you.
Take care. Next, 2017-63, 710 East Eager Street, Tom Rice.
Yeah, it's 710, but that's completely the wrong property. It's supposed to be 1020 Homewood,
Oh, gee.
and the problem that I'm having is this is 710. This is 712 that they say we're supposed to be zoned for. And our building is actually on the other side of the garage door, which is 1020 Homewood. Everything we applied for is coming up as 710, which is somebody else's property, and the 712 Eager is an empty lot. And we sent 10 emails to planning and phone calls, and no one ever called us back, or so zoning said, come here and state your case. So here I am.
Okay, I think I see what the problem is. Fortunately, I don't think that places you in a different zoning district.
All the applications, including the ones signed by Tom Wright, are for 710 East Eager Street.
Now, I think that it's really, frankly, I think it looks to be a distinction without a difference, because the property is on the corner. It's on, looks like most of it faces on Homewood. I guess it's a rectangular shaped property. The longest side fronts on Homewood. The shortest side fronts on East Eager Street. Really, it's as far as 710 East Eager or the address you stated on Homewood really refers to the same property within the same zoning district, the same, looks like the same dimensions of the property. Now yours,
I'm sorry. On the block plat, 710, like you said, 710 Homewood covers what formerly was 5 separate lots. But the address you mentioned, 1020 Homewood, is not one of those 5 lots.
Lots. No.
So should we? do
So yours
712?
isn't the,
So,
well, no, you can't use 712 East Eager because you're on Homewood, and 710 East Eager is the corner lot.
Right, but
Yours is
712
not,
gate.
there does not appear to be a 712. There is one property that is rectangular in shape, and it is known as 710 East Eager, and it comprises, as Mr. Tanner said, what formerly had been 5 different properties that appear to have been consolidated.
712 is the vacant lot?
No.
I,
Sir, identify your property on this piece of paper. Is it that?
Our property's right here. You go in Homewood, you go right in the building, which is on the other side of the vacant lot.
Okay, because what we have reflected there is that this right here is one parcel of property.
Right, I think he went and chopped the whole building into little sections.
So let me see if I've got, just a moment.
Okay.
If I'm understanding this correctly, this is a parcel of property, only a portion of which you're going to be occupying?
Right.
Okay, so the property owner owns all of this.
He owns the whole block.
That's correct. Well, it's not a block, but yes, he owns this entire property. So you're going to be in a part of it, but it's all the same piece of property, which is 710 East Eagle Street.
See, the only problem I have with that is 710 is an individual standing
No,
garage.
no, you're getting, so, like, when you look at a piece of property, might see a building that's located on it. That doesn't actually demarcate where the boundary line of the property is. So, if you see on this drawing here, there's a rectangular shaped lot. You'll see that within that rectangular shaped lot, there are these little dotted lines.
Okay,
Okay, those formerly used to be the boundary lines of 5 separate lots that have been now consolidated into one.
Okay.
So the structure might only be on what formerly had been this area here,
okay,
but the whole lot is now 710. You'll note that on this map here, there formerly are addresses at each of these different locations that are now crossed out, and the only one that exists is 710. So the part that you will be occupying, a part of this property, I can say that this happens kind of frequently when we've had commercial users that'll come into to occupy only one part of a larger commercial lot. But as I understand it here, the lot itself is 710, where the portion of which you will be occupying is some smaller portion of that. So the case here would not be to occupy the entirety of the premises. In fact, what we have as the proposal is to use a portion of the premises known as 712 East Eager as a garage for the storage, repair, and servicing of motor vehicles that will include body repair and automobile glass replacements. So from that description, we understand that you will be only occupying the portion which had been known as 712.
I'm gonna say okay. But my only concern is the 710 is empty right now.
Mm-hmm.
It's up for rent, and I don't wanna cause that.
Well,
many
you won't be.
problems.
You won't be.
Okay.
You won't be.
I
Well,
think
we don't have a problem.
we,
But-
ne- we may need to sit down with you, if the board approves it, we make sure we'll get it right. So
Yeah,
that
if
when
you-
your permit is issued, it's issued
Well, yeah, 'cause they
to,
sent me planning, sent me a jigger and a whole bunch of adults, and if you see my lot, you would say, oh, we don't need it there, because there's no public street that we're working on or anything like that. There are like no cars on the street, no dumpsters, gotta have a wooden, we have a.
Planning is always going to require those, because even though the portion of the lot that you may be occupying doesn't front on a street and may be within some landlocked portion of the property, since the approval follows the property, not just the user.
Okay.
So if you move out, the property has already been approved for a certain use, it prevents another user from coming in, and then if they're operating a repair garage, parking all their cars on the street and that kind of thing. So, and as I look at it here, there's a drawing that I think reflects, is this it?
Wait, all this out here
Mhm.
is parking lot.
Okay, all right, good. So we have a drawing of the property, and I think there's the vacant lot you were talking about.
Yeah, and that's our building there, yep.
Okay, great, so we have everything. Now moving back.
That was easy, huh?
Well, we're not done yet. We haven't even started. Have a seat. I mean, not have a seat, just, no, actually, if you can stand there. All right, Mr. Rice, we have this as an application to use a portion known as 712 East Eager as an auto repair garage. Is that correct?
Yes.
All right. Mr. French, anything for the planning department?
Thank you. Planning Department recommends that approval of this application be subject to these conditions. There will be no parking, staging, or storing of vehicles on public rights-of-way. There will be no parking or storage of unlicensed vehicles on the property. All work must be performed indoors. All materials, parts, and equipment related to this use will be stored indoors. The area used for temporary storing of vehicles will be adequately screened by an opaque fence or wall. And if a dumpster is used to collect waste and trash related to this use, the dumpster will be placed either inside the existing building or within a masonry enclosure having a solid lockable wooden gate. Thank you.
Okay. And Mr. Rice, just a moment. Mr. Rice, are those conditions stated by the planning department acceptable to you?
No.
Okay.
The reason why, if we have a dumpster, we have a 12-foot steel gate already.
So you're
Whole
gonna
property.
comply.
Whole property is 12 foot, only red.
Okay.
Can't get her out without coming through a lock gate. Number two is we do a lot of state inspection work. So
Okay, are you saying, well, Mr. French,
Mm-hmm.
the condition related to a dumpster was what again?
Wooden fence. Or inside.
Just a moment.
If a dumpster is used to collect waste and trash, the dumpster will be placed either inside the existing building or within a masonry enclosure having a solid lockable wooden gate.
Okay. The property being ringed by a steel fence, as indicated by the applicant, is that acceptable to the planning department?
The idea of the solid lockable wooden gate was it would prevent, number one, viewing of the dumpster, and number two, easy penetration by rodents. So we prefer to have a solid gate rather than a chain link type of fence gate.
Okay. Although I guess if you're only occupying a portion of it, you can't really commit the owner to a condition, and the owner's not here, is that correct?
It is not.
Okay. So what was the next thing?
My next thing is we do a lot of state inspection work and cars come over with no tags on them.
Okay.
So I would say, give me X amount of days that a vehicle can sit on our lot with no tags, because they're getting no tags to be state inspected for the state of Maryland.
Okay. Is there some time frame, Mr. French, which would be acceptable?
Actually, we would normally leave that to zoning administration to determine what is storage.
Okay.
We state no parking or storage of unlicensed vehicles on the property. I think the storage is the key issue as to how long they would remain on the property unlicensed before they're either taken away or given a license.
Okay. So,
Basically, what they just want to make sure is that you're not operating a junkyard where you've just got.
oh, right,
yeah,
right.
yeah,
I understand that.
yeah.
Okay, so where we at with this dumpster? Because my other rebuttal with the dumpster, even if it's wooden, a rat wants over, rat's going over, but there's no food in it. It's all automotive.
That's right.
Glass and
It's all automotive
parts.
parts. I was going to say, well, I was going to ask Mr. French, since the fence is a portion of the property owned by the property owner, and the property owner isn't here to agree to a condition like that. Is the current fence located on the property acceptable to the planning department, given, as the applicant has represented, that the dumpster is, well, the dumpster will contain automotive parts, not food waste?
I think we would find that acceptable.
Okay. Everything else in accord?
I think so.
Okay, anything further?
I hope not.
All right, Mr. Rice, zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal. Good luck. Next, 2017-66, 261 Southeast Avenue, Travis Lockman.
Good afternoon.
Afternoon, sir. We have this an application to construct a second floor rear addition with rear and rooftop decks at this location. Is that correct?
That's correct.
All right. And Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Okay, and Mr. Lockman, anything further you'd like to add to supplement the record in your case?
Just was hoping to, if you guys hadn't already received this letter of support from Highlandtown Community Association, just want to make sure.
Okay,
I believe we have that.
we do have it. Okay.
There it is, in color, too. Thank you.
Anything else?
No, nothing further, thank you.
Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Wonderful.
You got another one here, so let's jump to that. 2017-76, 820 South Decker Street, which is also Travis Lockman. Mr. Lockman, we have this as an application to construct a second floor rear addition with two-story side infill addition with rear and rooftop decks. Is that correct?
That is correct.
All right. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
All right. And Mr. Lockman, anything further you'd like to add something to supplement the record with respect to this appeal?
Nothing further.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
Take care.
You guys, too.
All right. Next, 2017-69, 309 South Duncan Street, Kareem Hareed.
Afternoon.
Afternoon, sir. We have this an application to construct a second floor rear addition with rear deck and new third floor and rooftop deck at this location. Is that correct?
Yes, sir.
All right. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
All right. And Mr. Hareed, anything further you would like to add to supplement the record in your case?
No, sir.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
Take care. Good luck. Next, 2017-77, 1920 Gulf Street, Rich Poland.
Yes.
Afternoon, sir. We have this an application to use the premises as an office and 2 dwelling units. Is that correct?
Yes.
Mr. French, anything for the planning department?
Planning Department recommends approval of this application.
All right. And Mr. Poland, anything further you would like to add to supplement the record in your case?
The owner will be the occupant of the office, and the laundromat that was formerly there was in operation into December of 2016.
Okay. Is that it?
Yes.
All right. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve your appeal.
Thank you.
Good luck. Next up, 2017-78, 2521 North Charles Street, William Shaughnessy.
Good afternoon. With me is Sandy Timmons, who is Executive Director of House of Ruth. Mr. Chair and members of the board.
Afternoon. We have this, Mr. Shaughnessy, as an application to use the premises as a nonprofit community center. Is that correct?
Correct.
Mr. French, anything for the planning department?
Planning Department recommends approval of this application. Thank you.
All right. Mr. Shaughnessy, anything further you would like to add to something in the record in your case?
I'd just like to verify that the letter of support from Charles Village Civic Association is in. Thank you. Nothing further.
All right. Good.
For the record.
Oh.
How y'all doing? Councilman Stokes, I just wanted to stop past and, I'm sorry, I didn't know.
Read your
who
letter.
I'd also like to make sure that Councilman Stokes gets a chance to speak.
No, I just want to stop past. House of Ruth has done some wonderful things in the city, so they have a great track record. So I want to stop past and let them know that they have my full support.
Thank you very much.
Thank you.
Thank you very much for that, Councilman. Anything further, Mr. Shaughnessy?
Submit Councilman Stokes.
Thank you. And with that, anything else?
Nothing further.
Okay. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
Good luck. Thank you. Next up, 2017-79, 2100 Alisana Street, Lynn Ha.
Good afternoon.
Afternoon, ma'am. We have this as an application to add microblading, which is cosmetic tattooing, to a beauty salon. Is that correct?
Yes.
All right. Mr. French, anything from the planning department?
Yes, Planning Department recommends approval of this application, subject to these conditions. Cosmetic tattooing or microblading occurs only during normal business hours of the existing beauty shop. All tattooing is done by appointment only, with no walk-ins, and no exterior signage advertises availability of tattooing on the premises. Thank you.
All right. And ma'am, are those conditions acceptable to you?
I accept.
Okay. Anything further to supplement the record in your case?
I would like to see if any of the judges would like to know what's microblading and further more detail.
We
have
have
some
a
the question.
generic understanding of the process.
That would be all.
Okay. Zoning board staff having previously reviewed the application, we have determined that there is sufficient information to approve the appeal.
Thank you.
Good luck to you.
Have a good one.
Next up, 2017-80, 1544 William Street, Jennifer Nardi.
I'm Michael Walsh, Stanton Home Construction, on behalf of Ms. Nardi.
Afternoon, sir. That last name again was?
Michael Walsh.
Walsh, okay. Mr. Walsh, we have this as an application to construct a raised first-floor rear deck at this location. Is that correct?
Yes.
And Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Okay. And Mr. Walsh, anything further you would like to add something to the record in your case?
No.
Okay. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve the appeal.
Okay, thanks.
Good luck. Last, 2017-82, 409 South Register Street, John Cole. All right. You're not concerned. You're not concerned. Oh, that's it. And you need to go? You need to go? Okay. Okay, good. All right. All right, that concludes our consent agenda cases. Next, we'll turn to those cases which will include cases where there's opposition which is signed in. Frequently, we found that opposition is a result of either a lack of communication or miscommunication among the parties, and it can be useful to offer the parties an opportunity to enter in, to have a dialogue with one another to see if they can resolve whatever differences they have between them and reach some sort of an agreement. Obviously, if two opposing parties are in a dispute and ask the board to resolve that dispute, one of those two parties is bound to go away disappointed with the outcome, and so this is your opportunity to avoid that unhappy fate. I'm going to call off the cases where opposition is signed in and just ask that you stand where you are. We'll ask whether or not there has been any dialogue between the parties, and whether or not the parties think that continued dialogue or having a dialogue now might lead to a resolution of whatever issues that they may have outstanding. He's not obligated to take the offer to speak with the opposing party, but of course it is encouraged and appreciated. First case where there's opposition which is signed in is 2017-68, 719 Grundy Street, Ken Sikora.
You need help, Roberta? With the opposition.
Okay. And folks, have there been any dialogue between the parties?
There has, yeah, if you're open to speaking if they'd like, if not,
I think we want to present our case to the board.
Okay, have a seat.
All right.
I know the answer to this. 2017-73, 5715 Roland Avenue, Caroline Hecker. Okay. Folks, any prospect of a dialogue?
My clients, I'm here on behalf of the Taylors who live next door, and we're ready to proceed.
All right.
Mr. Chairman, I don't know if other folks in the neighborhood want to do otherwise.
Desire for a dialogue?
I'm here on behalf of other neighbors.
Mm-hmm.
agreement among all the neighbors to proceed to discuss, it doesn't make much sense to.
Understandable. All right, have a seat. Next, 2017-75, 1821 through 1831 West Lafayette Avenue. All right, and who signed in on? Back here? Oh, okay, over there. All right, and have you folks had an opportunity to have a discussion? You have not? Okay. And ma'am, you're the owner or the opposition? Okay. Okay, folks, desire to talk to the property owner? Okay, have a seat. Okay, and last, one more with opposition is 2017-85, 4708 Harford Road. They might be outside. Okay.
Mr. Chairman?
Yes.
409 South Register Street on the consent.
Mm-hmm.
I do a fair amount of work with the applicant. I just
Okay.
called him. He said it was okay if I stood in. His
Okay.
builder didn't show up, so I didn't want him to miss it.
All right. All right, we'll call, that was the last case on their consent, which was? 82. There we go. 2017-82, 409 South Register, John Cole. All right, Mr. Prettle, you've previously been sworn. You're appearing for Mr. Cole?
Correct.
All right. We have this an application to construct a 3-story rear addition with rear and rooftop decks at this location. Is that correct?
I think so, yes.
Okay. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
And Mr. Prettle, I presume nothing further you'd like to add to something the record in this case?
No.
All right. Zoning Board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Great, thank you.
Thank you for standing in for Mr. Cole. All right, let's jump to 2017-54, 1712 Harlem Avenue. Oladayu Oladokum. All right, sir. You're Mr. Oladokum?
That's correct, sir.
All right. Sir, we have this an application to use the premises as 3 dwelling units. Is that correct?
Yes.
All right.
Existing 3 dwelling unit.
I'm sorry?
Existing 3 dwelling unit.
Okay. If you can raise your right hand to be sworn, please.
You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes. Correct.
All right, and do we have staff reports?
We have one report from planning.
Thank you. Planning Department reviewed this application, noted that this property was in fact at one time authorized for use as a multiple family dwelling. However, the department also notes that the property has been subject to vacant house notices since 2010, which has caused the property to have the status now of a single-family dwelling according to the zoning code. This property is located in an R8 zoning district in which conversion of a single-family dwelling to multiple-family dwelling can only be authorized by ordinance of the mayor and city council. On that basis, the Department of Planning recommends disapproval of this application because the zoning code does not provide the board discretionary authority to approve conversion of a single-family dwelling structure to multiple-family dwelling use in an R8 zoning district where this property is located. Thank you.
Okay. Thanks. All right, Mr. Oladokum.
Yes, sir.
Did you understand all that from the planning department? All right. Why don't you tell us a little about, I think sort of the long and the short of it is that the property has been vacant.
No, it's not vacant.
It sounds like, well, there have been vacant house notices issued. Their earliest one was in July 19th, 2010.
Yeah.
And there have been, Mr. French, am I correct? There have been others issued since then?
There were several issued, as we understand it, primarily because of change of ownership. The previous notice would be canceled, and then a new notice would be issued to the new owner.
Okay. So there have been a number of vacant house notices which have been issued for this property over the years. And by law, at that point, the property reverts to being a single-family dwelling. At this point, that multifamily use can only be reestablished by an ordinance by the mayor and city council. And the way to achieve that would be to reach out to your council person, Mr. Bullock, to investigate the filing of an ordinance to reestablish the multifamily use at this location.
Yeah, but what I'm confused about is because before I acquired the property, it was already a multi-dwelling property. All I did was fix it and clean it up and rent it out. And
Whoever you may have purchased it from may have been using it as a multi-family dwelling, notwithstanding the fact that the multifamily use had been lost. So it may not have been an authorized use. They may have been using it despite the violation, and they just simply decided not to get it cured. So you're in the situation now where you purchased it from them, and now you're finding out that it lost that multifamily use.
But before 2016-15, I've already been paying the city as a multi-dwelling unit. I paid the fee as a multi-dwelling unit. So when I did finish the property, they told me to get a permit. I got the permit. They never showed up to come inspect it as a multi-dwelling unit. So it was my fault from the outset. I did what I'm supposed to do. I've been filing, doing everything I'm supposed to through the city, and they just didn't come out to do what they're supposed to, and they revert back to a multi-dwelling.
Well, as I said, the long and the short of it is that since 2010, there have been uncured vacant building notices issued. That's a 7-year time period. Now, you, I guess, have indicated that you purchased the property, yes, in 2015. You've been fixing it up since then?
It's fixed. People living there as we speak. And I got witnesses that come to tell you that even the same block
Sir, all that I'm telling you is this board doesn't have the authority to give you what you're seeking.
Okay.
I have told you how you can achieve that, which is by going to the councilman and asking him to submit a bill to authorize the use of this property as a multiple family use. You'd explain to him the same thing that you proposed to inform the board about, and you'll have to work through his office to seek the introduction of an ordinance. But the board, given the fact that there's the documented history of the vacant building notices, at that point, once those went uncured, the property reverted back.
Okay. Basically, that's it.
That's kind of the unfortunate aspect of it, but if you haven't met the councilman, but I'm sure that you have, it sounds like you have a meritorious basis for seeking it, particularly given the fact that there's a history of multiple family use and you've improved the property. And the consequence of not getting approval would be that whomever is living there now would have to move out. So they may be receptive. I can't speak for the councilman's office one way or another, however.
Okay.
Okay?
All right, thank you.
All right, thank you very much, sir. Okay, next up, 2017-83, 707 South Glover Street. No, not South Glover. 2017-85, 4708 Harford Road, Thomas Cobb. Just a moment, gentlemen. Okay. Okay, you're Mr. Cobb?
Yes, sir.
All right, and Mr. Cobb, we have this as an application to use the front portion of the first floor for a 50-seat church to continue remainder of building for 5 dwelling units, all as a mixed-use, multiple-family detached dwelling. Is that correct?
Yes, sir.
All right. If all those intending to give testimony can raise their right hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. And do we have staff reports?
Yes, first we have over a dozen letters from residents, business owners, and their local associations expressing opposition to this proposal. To summarize, the residents and local business operators describe illegal activity, loitering, public intoxication, and prostitution at 4708 Harford Road. On many occasions, they have observed school-aged children participating. While it is not directly related to this property, a murder recently occurred steps away from this property. Many in opposition request a postponement or denial until the owner provides some documented proof that the community's observations are unfounded and information describing the use's impact on the residential areas and the Harford Road Business District. The Waltherson and Beverly Hill Associations, the Harford Road Community Review Panel, the Hamilton-Lauraville Main Street Revitalization Program, and Harbell, they write that the property has lacked a use and occupancy permit for the past 15 years. There is not enough off-street parking for the rentals and the church, as they are already overwhelmed the existing available parking. The property is in violation of the urban renewal plan and in very poor repair. These problems and the neighbors' observations, which the associations confirm, make the property and the owner an overwhelming problem in itself and an obstacle to and discouraging new development in the 47 and 4800 blocks at Harford Road. Does planning have a report?
Planning Department reviewed this application, noted that this property is located within the Lauraville Business District Urban Renewal Plan area. This urban renewal plan contains a provision which requires off-street parking be provided for religious institutions, churches, and such, at the rate equivalent in the zoning code of 1 parking space per 4 seats of rated capacity. In this situation, the applicant is asking for approval of a 50-seat church, which therefore requires the provision of 13 off-street parking spaces. The applicant has not indicated in the application that there is a provision of off-street parking in connection with the proposed use. The Planning Department therefore recommends, on the basis of this lack of information, disapproval of the application, because the amount of variance of off-street parking standards needed for approval would exceed the board's discretionary authority, which is the 75% limitation, and would call for 100% waiver. And because the Lauraville Business District Urban Renewal Plan requires 1 off-street parking space per 4 seats in a religious institution. This urban renewal plan, the department notes, does contain a provision providing that upon application, a waiver may be sought and granted by the Commissioner of Housing and Community Development, and therefore notes that the board could approve the application subject to the condition that the applicant receives a waiver of the urban renewal plan's off-street parking standard from the Commissioner of Housing and Community Development. But the department encourages the applicant to identify off-street parking resources first. Thank you.
Thank you. Okay, Mr. Cobb. Is taking the lead from planning. If you could tell us what's being proposed, and if during your presentation you could also discuss availability of or your efforts to investigate what parking resources might be available.
Yes, sir. We have, there should be 2 letters already in the file. I have 2 copies of them here of both cross-street parking and down the street parking. Both Paul Cho and the other gentleman there have offered us to allow us to use their parking. We don't usually need it because we park on the street. It's on our service is usually on Sunday. So, but we do have that, and it should be already in the file that we that this has been offered. We should also show that these businesses appreciate us being in the community and are willing to help us be there. I'm sorry that this is the first time I've heard some of these other accusations. I wish these folks would have come to us before this, and we wouldn't have taken your time here, but as far as fixing up the building, we've had the whole building. We actually have a Spanish congregation that meets on Saturday evening, and they volunteered to paint the whole building, so we just got that painted. Got a little touch-up to do this when it gets spring again, but we're painting the building. We're fixing the building up. When we bought the building, about the only thing was good in it was the ceiling in the sanctuary part, church part, and but we have totally renovated the whole inside of the building, even the apartments that are there, and to help with people that are trying to get back on their feet. So as far as the other things, I'm going to try to. I've had the police to come and help me to deal with any problems we've had around the building. I didn't even know someone was shot around the building. The first time I ever heard that. I'm not sure where that happened, but as far as the other activities, there's kids coming up down the street all the time, and the police said they stop at different places, and we got to call them almost every day to help the young people to move on, because they do a lot or sometimes and cause problems. Trying to be friendly with the community and trying to be a help to the community. Other than that, we've tried to tell them to move on and not to be a nuisance to you. But they do this all up and down 40, up Harford Road. So I don't know.
And you said that the church had purchased the building. When was that?
We purchased it in 2007.
Okay. And have you been there since that time?
Yes, sir. Yes, sir. We have been in the building. In fact, a Nigerian church had it before us, and they bought it. They had it in 2001, and so we thought when we got it, it already had zoning because they were having church there all that time. So we figured there wasn't an issue, even though I've tried to work on that issue, through the years, but and do everything we can.
Okay. What did we do with those letters? Are they down there?
Down here.
Well, Councilman, have you seen those, by the way?
I have not seen these.
Okay, if you can pass those up.
These letters, this one's dated 2002, and this one, I believe, is 7, but somebody scratched a 1 across the 0 and made it 17. In the previous appeal from 2002, the board authorized a use of a portion of the property for a 50-feet church. And as a condition of that appeal, parking came up as an issue, and I believe that's when these letters were submitted to the record.
And we used them again, and they were accepted in 2007, I believe it was. So between 2007 and 2010, I can't know the exact date there.
I'd like to hear it.
We don't have a record of 2007.
It appears pretty clearly that the date has been changed on here from 2007.
We can get to that. We can get to that. So what discussions have you had recently with any adjacent property owners regarding availability of or the ability to use any parking facilities that they have for the church?
Well, again, I didn't know till today that it was going to be an issue, but I did go down and try to talk to Mr. Choi and to get that letter updated. I've talked to Mr. Roy within the last couple of years, and he's always, in fact, he's even allow us to have like church fairs over there, where we brought in things to bring in the community, to bring the community together, like block parties and stuff. So I know he wouldn't have a problem.
Now, the individual that you said that you'd spoken to recently, was that Mr. Roy?
That's correct.
How many parking spaces do they have?
35 spaces.
Okay, 35. All right, and the requirement here is for 13. And how close is that to your property?
Right across the street.
Okay, all right. And you said you've spoken with him recently about that?
With Mr. Roy?
Yes.
Within the last couple of years, yes, sir.
Okay. I thought you said there was someone he'd spoken to more recently than that.
Mr. Choi, I was trying to get with him today.
Okay.
But he wasn't in. The representative there at his cleaners, which is where I get my clothes cleaned and all, he is supposed to get back with me.
Okay.
Like I said, I didn't know I was even going to need that till today. I thought the letters that we already had in the file was accepted.
All right. And have you had occasion to use Mr. Roy's facilities? That's the gentleman who you said, I think it's across the street from you?
Yeah, Mr. Roy. No, sir, we've never needed them, except for that block party that we had.
Okay. And when was that approximately?
About 2 years ago, we had a block party there.
Okay. All right. About how many people do you have come to services?
We're probably running about 25 or 30 right now.
Okay.
And then we have the Hispanic service, which is on Saturday evening. They probably run about 15 or 20.
Okay. And how frequently do you have congregants at the church?
The one church twice a week, and then the Spanish service meets once a week.
Okay, so 3 times a week?
Yes, sir.
All right. And which days are your services on?
I'm sorry?
What days?
Oh,
do you
that's
have
on
services?
Thursday, Saturday, and Sunday.
Okay, Thursday, Saturday.
Which that's Thursday night. Again, the parking is not being used then either.
Okay. My next question was going to be hours, so that's Thursday evenings?
Yes, Thursday evening at from 7 to 9.
And then on Saturdays?
Saturdays from 7, I would say 7 to 9.
And that's PM?
Yes, sir, PM, yes, sir.
And then your Sunday services?
Is from 10 to 12 approximately.
AM?
AM, yes, sir.
All right. Anything further for right now?
No, sir, I believe that's it. Except maybe I would say that we were, again, they just came to me today, this meeting, so we are talking and trying to correct any problems that we may be having there, and I will do whatever I have to do to correct the problems.
Okay. Fair to say that the church doesn't promote juvenile drug use or prostitution?
No, sir.
Okay. Counsel.
Thank you. First, I just want to thank you to the board, Mr. Chairman. First, I do want to note this letter of permission for parking is dated 2002 for Mr. Cho. The other letter here from Mr. Roy seems pretty clearly to have once been dated 2007 and been changed to say 2017. And it's particularly suspicious that it should be dated March 15th, 2017, since Mr. Roy no longer owns this property as of several months ago, let alone March 15th, 2017. I have had countless calls to my office and emails from concerned constituents, including ones who work directly across the street from the property and live less than 1 block from the property, where they have witnessed, as was mentioned, children standing outside of the property during school day, counting cash, waiting for people to come to the door to what seems pretty clearly sell drugs from inside the residential part of the property, the 5 residential units there. I have personally witnessed hand-to-hand transactions in front of this property involving people who are coming to the door from the residents in order to perform these hand-to-hand transactions, as well as others congregating in the open doorway of the residential area consuming what seems pretty clearly to be alcoholic beverages in paper bags.
Have you discussed those with the church at all?
I have not. This is the first time we've met today.
Okay. So you've been getting these reports, but you didn't go to the church?
My, the
I understand you just got in the office just a few months ago.
Yeah. But we also, really, it's only the case coming up here today that was very recently brought to my attention that was the impetus for this conversation.
Okay. Just, I mentioned because I'm taking Mr. Cobb's statements, he seemed to indicate that that those were matters which the church would be concerned about as well, and it sounds like he's expressing a willingness to work with the community to address those, in as much as the church doesn't promote drug use and prostitution.
I would be most willing to defer to the other representatives of the community and their willingness to come to an agreement as to something that would be amenable to the community.
Okay.
And support that and be willing to host that dialogue to the best of my capacity.
I think that'd be very valuable use of your resources. Is there,
We have
Harbell
two such people.
have a
Well-
position to express?
Yes, real quick. 4719 Hartford Road is
Just
owned by
for the
Soho
record,
Road.
if you-
Mike Gilliard, Community Services Director of Hartford. Excuse me, Mr. Chairman.
That's okay.
4719 Hartford Road is now owned by Soha Row LLC. The letter is from Jim Roy of the American Beauty Academy. The American Beauty Academy went out of business, 3 to 4 years ago?
Something like
And
that.
the property was then bought and is now under development. This is a late letter from the Moravia Walter Improvement Association, which recites opposition for a lot of the reasons Mr. Henry and Mr. French said, and some of the reasons Councilman Dorsey came up with. But I think if the appellant's willing to postpone this hearing, if the board can grant the use, we would be willing to attempt to negotiate an MOU prior to going on with this.
I would again like to voice reservations based on the fact that what seems like pretty clearly falsified documentation has been submitted before this board.
All right, and ma'am?
I think I'm Regina Lansing from Hamilton Largo Main Street, and I think what Mike Hilliard says pretty much summarizes what our Main Street position is.
Okay.
But obviously, if the board can't deal with the issue because the planning cited its recommendation, that the MOU would be a moot issue, so.
It occurs to me that there's, just looking at it, the issue highlighted by the zoning administrator's office was the issue regarding parking, which isn't really an issue that's been brought up by the opposition. And it sounds like the issues that the opposition is concerned with are issues which the applicant would be concerned with as well. In as much as there hasn't been a dialogue prior to today, and frankly, all the parties sound like they're willing to use their efforts to try to come up with a way to address what sound like common concerns. Mr. Cobb, would there be a willingness to postpone today's hearing so that you could have a dialogue with the community by way of the offices of the councilman's office to see if there's an ability to reach a memorandum of understanding so that you as the applicant and the community can all be satisfied that there's common ground to move forward in addressing what sound like issues which concern all of you.
Yes, sir. In fact, I've already been in touch with the councilman's office. I have not been able to schedule anything with him.
Okay.
But his representative there, Corey, I've talked to him and have an appointment for Thursday.
Okay.
So I'm more than willing to, if that's what you.
Okay. Well,
I'm more than willing to work with that.
all right. And Councilman, how long do you think that you folks would need to sit down and hammer something out?
Scheduling is kind of difficult these days.
I would say at least a month in order to address some of the neighborhood associations that have written letters.
Okay.
I would certainly want Mr. Cobb to come before the Community Association, whose next meeting is on April 11th.
Okay. And that's fine with you? Okay.
Mr. Chair,
and-
the issue really is, and candidly, my letter did cite parking.
It did
is the
bring it up.
primary issue. But the issue with negotiating an MOU is you've got multiple community associations involved in this.
Mhm.
Attempting to schedule and coordinate that would take time.
Okay, but, I mean, I'll imagine that there is an ability, I mean, the applicant already is gonna be meeting, it sounds like he's got a meeting with the councilman's office on Thursday. I'll imagine that there's, probably some time between now and, say, a month from now for representatives from, either from the representatives from the affected community groups or yourself on their behalf, to meet with Mr. Cobb and a representative of the councilman's office so that people of good conscience can sit down and work something out. I wouldn't imagine that would be too strenuous of an undertaking.
That seems okay.
Okay?
Do whatever.
I'll defer to the
Okay.
councilman's infinite wisdom in this matter.
Infinite. You heard it here first.
He's gonna
He
keep
did
that
say
tape
it.
and use it against me. I'm sure.
All right, so then,
know.
2017-85, 4708 Hartford Road is postponed. And folks, when you're ready to come forward again, just give a call to the zoning board office. Do I have any cards? I do.
And I think you guys still have one of his exhibits. Do you want to pass that back up?
Just calling the zoning board office when you guys have something worked out, and then we'll get you in on the next available date, and hopefully get you back in here on a consent to put an agreement on the record.
Thank you, Mr. Chairman and the board.
Thank you.
Sir, appreciate your help.
All right, we're gonna take a quick 3-minute recess. Oh, no, that's right, we have to wait for Fred to come back before we can. Yeah. All right, and we'll go back on the record. All right, we'll call 2017-58, 501 North Ethel Avenue, Harry Connolly.
We don't believe he's here.
Yeah, I just wanted to call the case for the record to allow, to see if someone's gonna come forward. Okay, so that's a no-show. All right, well, let's jump in with both feet. 2017-73, 5715 Roland Avenue, Caroline Hecker. No? All right, Ms. Hecker.
Good afternoon.
Good afternoon. All right, we have this as a appeal of a revocation of use permit, 2016-03740, and relief from subsection 4-107B2. Is that correct?
Yes, that's correct.
All right. If all those intending to give testimony can raise their right hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
All right, and can counsel identify themselves for the record, please?
Good afternoon. Caroline Hecker, Rosenberg, Martin, Greenberg. On behalf of the applicant, I'm joined by my colleague, Justin Williams.
Okay, thank you.
Good afternoon, everyone. Michael McCann on behalf of Angela and Dan Taylor to my left here, who live at 5717. 5801. I'm sorry, Roland Avenue.
He's in the bill somewhere.
I am Jeffrey Scher on behalf of Lee Ogburn and Natalie McSherry and Stuart Serena, all who live within the block of the 5715.
All right. Thank you all, council. As we had discussed briefly off the record, since this is a appeal from since this appeal concerns a prior appeal which the board recently heard 3 months ago, and there was a full hearing in that case, much of the testimony and the facts are known to the parties. And so, given that there are a number of potential witnesses involved in the case, there was a discussion off the record regarding how to proceed and how to present the cases. And as I believe that we agreed on, there will be liberal allowance for testimony by way of proffer, particularly of witnesses who've already testified, and that where cross-examination is desired on any points addressed by the proffer, that of course the adverse party has the ability to call that witness to examine any of those points further. And Mr. McCann, I think that you had indicated that your client had additionally wanted to testify, and also made me aware that there are some witnesses who were not here previously who may also want to give testimony, although certainly you're mindful that you don't want to do a lot of duplication between witnesses. So, with that understood, we'll turn to staff reports.
Okay, yes, we have received letters from residents expressing both opposition and support of this appeal. In support, 2 residents write that even if there is a code violation, the home at 5715 Roland Avenue is a welcome addition to their community. The color, the facade, and the roof look very nice. The 5715 Roland Avenue is near their home and set back from the street, similar to their home. Then we have 6 residents and the North Roland Park Association and the local community association, and to combine and summarize their opposition, they want the zoning code subsection 4-107 enforced. They want the terms of a December 8th, 1998 covenant within the subdivision plans as filed with the City Department of Planning, located in City Archives in folder 99-0007. Between the North Roland Park Improvement Association and Victoria Park Association Limited Partnership, requiring an 85-foot front setback, slate or wood roofing shingles, and matching stone veneer on all sides of the building to be honored and enforced by the city. That their complaints concerning the violations go back to when the construction began, and that the continued completion of the house is no justification for the city staff incompetence and the resulting building codes noncompliance. To comply, the house would likely have to be raised. That is the end of reports.
The Planning Department has no comment on this application. Thank you.
Thank you. All right, Ms. Hecker.
Thank you. As you all know, this is a case involving a house that was constructed 10 feet into the required front yard setback. This isn't a case where there was any sort of attempt to sneak something through past the permit office. The applicant here applied for permits. The permits with the plans, with showing the existing setback, were reviewed and approved by the city. The permit was issued. The property was inspected in the ordinary course. And ultimately, a use and occupancy permit was issued last summer for the property. We understand that obviously there are some neighbors who have some concerns about the proximity of the existing house to Roland Avenue. And, you know, Mr. Naylor is trying to be a good neighbor here, and we've offered to try to do some things to try to mitigate the impact of the house on the property, including, you know, planting some shrubbery or some trees, possibly painting the sides of the house a darker color to sort of mitigate the impact of the house. And we haven't gotten a lot of traction with the community. I think, you know, at the end of the day, we're talking about 10 feet, and if the house were required to be moved back 10 feet, that's really not going to have a measurable impact, whereas some of the things that we possibly could do to mitigate it would actually have an impact. I think, we're going to hear today about how the neighbors think that this is self-created hardship and that the variance isn't the minimum necessary to afford relief. And I'll go into all this in more detail later. The hardship at issue here is created by the unique characteristics of the property and not by any action of Mr. Naylor. And the requested variance is the minimum necessary to afford him the reasonable use of his property. I'd like to go over a bit briefly the sort of historical situation, how we've come to arrive here. And Mr. Williams has some exhibits that I'll walk through just sort of in detail. These are, in large part, things that are already part of the record. In fact, I think almost everything in here should already be part of the record, but we've organized it all into one place for you all. In 1999, the Planning Commission approved the subdivision of 5713 Roland Avenue into 3 lots. The existing 5713 Roland Avenue was improved with a multifamily dwelling that had 5 units. There was also a carriage house in the rear at 5711. It was given the address 5711, which was proposed to be renovated and converted into a single-family home. And then at 5715, which is the subject property, that was a vacant lot that was slated for redevelopment as a single-family home. And you'll see in the file that I've handed out a copy of the final subdivision plan that was recorded is included as Exhibit 2 in that file. I've also included a copy of the Planning Commission staff report in the file, which indicates that the applicant was not requesting development plan approval for lots 1 or 3, with lot 1 being the subject property here, in this case 5715, and that the building footprint, therefore, that's shown on that subdivision plan was not intended to be the final approved footprint of a building on that lot, and that any further development obviously would require further approval. I've also included a copy of the zoning board's decision in the case involving the existing 5713 multifamily dwelling, modifying the conditional use for that case. Now, Mr. Naylor purchased the property in 2014, long after the 1999 subdivision, with the intent of constructing a single-family home on the property. He obtained a building permit, a copy of which is included in the file, and along with a site plan showing the proposed building. He wanted to construct a single-family home with an attached garage. There were no timely appeals that were filed on the building permit application. Construction proceeded in accordance with the permit. The building was inspected in the ordinary course by the city's building inspectors. And on August 10th, 2016, a use and occupancy permit was issued to use the property as a single-family dwelling. There were no timely appeals filed of the use and occupancy permit either. But at the end of August, the North Roland Park Association sent a letter to the board ostensibly appealing both the building permit and the use and occupancy permit for the property, which led to, in September of last year, the city advising Mr. Naylor that, in fact, his home was constructed within the required setback. He didn't have any knowledge of it until that point. And the city acknowledged that an error had been made in reviewing the plans, and told Mr. Naylor in the letter that he needed to apply to the board for a 10-foot variance from the setback requirements. And that letter is included as Exhibit 7 in the file. So in accordance with the city's instruction, Mr. Naylor filed an appeal to the zoning board, and the board held a hearing in December of last year. And by decision dated January 13th, the board decided to dismiss Mr. Naylor's appeal, finding that it lacked jurisdiction to do anything because there was still a validly issued use and occupancy permit. Now, perhaps in an attempt to be helpful, I'm not really sure, the city then revoked the use and occupancy permit, I think in an attempt to get it properly back in front of the board. So that's how we arrived back at the zoning board here today. The city's letter is included as Exhibit 9, revoking the use and occupancy permit. So in any event, that's how we find ourselves here today, again in front of the zoning board, requesting a variance affirmatively now that we don't have a permit that is in effect at this time. So the subject property contains just over 18,000 square feet. It's located in the R2 zoning district. It's improved now with a single-family dwelling. It's approximately 4,000 square feet. It's 2.5 stories, and it has an attached garage in the rear. It was constructed, as I said, pursuant to a building permit that was reviewed and approved by the city. It's made of stone and masonry and hardy plank construction. It's designed to be in keeping with the scale and character of other homes in the neighborhood. And if you look at Exhibit 10 in the file, you'll see 2 views of the property. One is from the south side looking north, and you see a pretty clear view of the new home. The other is from the north side looking south, where you really don't see very much at all, and that's because it's entirely obstructed by trees. Mr. Naylor moved into with his family, moved into the home in last summer. They've been living there since that time, and this issue has sort of been percolating since obviously the use and occupancy permit was revoked. One of the other things to note is that the Planning Commission memo in 1999 noted that there are many significant trees on the property. There are 3 specimen trees, including a 44-inch diameter basswood tree at the center of the property, located in the forest conservation easement area in the rear. That forest conservation easement takes up about a third of an acre, and it occupies the entire rear of the property. The staff report from the 1999 Planning Commission hearing also noted that the property would have to be designed when they ultimately build a home to account for the trees, and that the trees were needed to be preserved and were important to be retained in the redevelopment of this property. In addition, this property is subject to stormwater regulations that are not, that the other properties on the block in this area are not subject to, by virtue of the fact that the existing structures were constructed long ago. New stormwater regulations went into effect in 2014 that require significant stormwater facilities to be constructed. And the impact of those regulations further limits the ability to develop this property and to construct a house on it. I've included a copy of the Stormwater Management Plan as Exhibit 11 in the file, and you can see that there is a 431 square foot landscape infiltration area in the rear of the property along the forest conservation area, as well as a 12-foot deep dry well that's located in the front yard. And those are necessary because the property is almost entirely flat. It doesn't drain, and so they need to account for the stormwater in some fashion. So ordinarily in the R2 district, a 30-foot front yard is required. But in this case, Section 4107B of the zoning code applies, and that requires us to average the front yard depths of the surrounding properties, the immediately adjacent properties, but provides that in no case is a front yard of more than 40 feet required. If we were going to average the depths of the properties, I think we'd end up somewhere in the neighborhood of 85 feet. It's much more than the 40-foot maximum, so we are going to be subject to the 40-foot maximum. As I said, the regular setback is 30 feet. That's what the house is built to, so we're really talking about this 10-foot difference in the front yard. Excuse me. The property...
Your opposition's been arguing, I think it was in one of the letters, about a deeper building setback. Can you address that?
A deeper building setback than the 85 feet that's shown on the...
Deeper than the 40-foot setback.
I believe, and I mean, I'll have to listen to what they have to say, but I believe that their position is driven by what's shown on the subdivision plan,
yes,
which shows an 82 or 85-foot setback, and that was what was shown on the subdivision plan back in 1999. Mm-hmm. That was not a proposed development, which is made clear in the staff report from the Planning Commission hearing on that. That just showed what a setback of a building could be, but there was no development plan approval at issue in that case. So that isn't binding on anyone.
Okay, I think that they had mentioned that their belief that there was that there are applicable covenants which require the setback.
I can address that also. There appears to have been an agreement by our client's predecessor in title when the property was subdivided. And I have a copy of it, which I'm happy to share with you, that we received from the North Roland Park Association a couple of weeks ago. It is not recorded, and it was not in our client's chain of title. This is a copy of the covenant. I'm sorry, I don't have multiple copies of it. I think you have a copy of it. I can also provide you a copy of our client's title policy, which does not identify these covenants as being in the chain of title or having any impact whatsoever on our client's property. I apologize, I only have one copy of that as well, but I'll
take a look at it. Thank you.
But those covenants were not recorded. And so when our client acquired the property in 2014, he had no knowledge of them. And, I understand that they were ostensibly supposed to be part of the subdivision plan in 1999, but I can't say whether it was inadvertence or what, but in any event, they were not recorded.
My question on the covenants is, even if they were recorded, is that something that this board has the authority to enforce?
It's really not. I mean, that would be a private action between the, benefited and burdened parties under the covenant. I don't believe that this board has any authority to enforce private covenants, a private agreement between the parties.
Thank you.
So, we believe the requirement is at most 40 feet in terms of what the setback could be required. And I believe that's consistent with what this board found in its January decision, which is that, we're really talking about 10 feet, which is not going to create much of a measurable difference for the folks who live along Roland Avenue who might feel that this property is constructed too close to Roland Avenue. I mean, you pull it back 10 feet and you're really not getting a whole lot of difference. But with regard to the sort of the standards that the board is required to consider and the findings the board's required to make with regard to the variance, the property is unique for several reasons. First of all, it's much smaller than any property in the area, in the R2 district located in this block of Roland Avenue. It's about half the size of the next biggest property, and you can see that pretty clearly on the tax plat, which is attached as Exhibit 12 in the exhibit. You can see it's highlighted in yellow, and it's much, much smaller than any of the other properties. At just over 18,000 square feet, the next smallest property is 33,000 square feet and change. They go up from there to 68,000 square feet. So this is much smaller. That's also shown on Exhibit 13, which is the zoning map, I believe, which shows the properties that are R2 are outlined in red, and you can see that this is much smaller than those. In addition, the property has a forest conservation easement in the rear, which is unique to this property. Most of the other properties in this area don't have a forest conservation easement. And that really restricts the ability of where you can build a house. You can't set it back too far because you'll be setting it back into that forest conservation easement. And in fact, the existence of the specimen trees also further restricts the ability to develop this property. And these are all things that well pre-exist, existed long before our client acquired the property. They were things that were either created as part of the subdivision plan in the case of the forest conservation easement, or the specimen trees were certainly there many years in advance of that. So these are not things that are that are created in any way by Mr. Naylor, but they are things that make the property unique and create the practical difficulty of where a house can be built. We would be asking for a variance, frankly, whether or not the house had already been built, or if this was a piece of vacant land.
Well, you say that your belief is that the applicable setback is 40 feet.
Mm-hmm.
And that the variance needed here is 10 feet, the difference between the 30-foot existing setback that it's built to and the 40-foot required setback under the code.
Mm-hmm.
Are you saying that because of the shape or size of the property that somehow necessitates that the structure be built where it is?
Not just the size of the property, but also that combined with the forest conservation easement and the location of the specimen trees all create in combination a set of unique factors that limit where you can construct the home.
Where does the forest conservation fall in relation to the property, in relation to the location of the house across, where does it fall across the property?
So the forest conservation easement, let's see if I can got my handy dandy thing here.
Here we go. I guess it's Exhibit 6.
Is it somewhere on that one? Which number is it? Oh, here. So, all right. Yeah, let's see, this is probably the best exhibit that shows it, is number 11, which is the stormwater management plan. And you'll see in the back of that property, it's about a third of the size of the whole lot as it goes towards the back. The rear part of the property is identified as a forest conservation. I'll hold this up so you can sort of see what I'm talking about. It's
okay.
The back third of the property back here.
Now, turning to Exhibit 6, that shows the layout of the structure, the property, the forest buffer easement.
Yes, and it's shown on there as well.
So given that your position is it's a 10-foot variance that's needed.
Uh-huh.
Starting from the front edge of the property, there's a 30-foot setback where that the structure is built to. Then you come to the 2.5-story single-family dwelling. There is a 10-foot covered breezeway. Then there's a 1.5-story 3-car garage. And then there is, you can't quite tell what the distance is there between the edge of the garage and the line of the forest buffer easement. But it looks close to that 10-foot covered breezeway, at least the distance, but it looks to be a little bit larger than that.
That's probably right.
So given that we're only talking about 10 feet, if the house were connected to the garage and there was no covered breezeway, wouldn't that be 40 feet?
If you were to scoot the house back so that there was no covered.
Yes. So say we could go out there with a magic wand and move the house and connect it to the garage, there's no breezeway, the forest buffer easement wouldn't have anything to do with that.
That's correct, but that would be a different design of house. That wouldn't be the house that was proposed.
Sure, but we're dealing with an as-built house. So if we went back to, if we were on day one of drawing this up, they were drawing up this plan and they knew that, okay, well, I've got a 40-foot setback. They draw a plan just without that covered breezeway. Or if the breezeway were desired, they'd build the edge of the first car of the garage to the edge of the forest buffer easement. You're able to keep the covered breezeway, and then you've got the 40-plus foot setback, and everything is.
I think that goes to the question of, is the applicant required to build a smaller house or a different house than what they are proposing?
Well, I think that even if you built the garage to the edge of the forest conservation easement, you kept the 10-foot covered breezeway, and you kept the dimensions of the house. So everything is as it is. It's just the house, the breezeway, and the garage are shifted back to be along the edge of the forest conservation easement.
You want to push the whole thing back?
Yeah, if you push all of that back.
The problem with that, but we can't do that, though.
Design of the house.
The problem is that there are stormwater facilities that are located in the rear behind the garage, in that area between the garage and the forest conservation easement. You can see that on Exhibit 11. And those are not allowed to be located in the forest conservation easement. So we're stuck with, we have exactly enough space.
What are the facilities?
There's a
I see a
landscape infiltration area.
See the landscape infiltration surface area, but that looks like that's outside of the area that's covered by the garage. So if you shifted the garage back, that wouldn't be affected. Because it looks like there's a distance there between the edge of the garage and the edge of that infiltration surface area.
I believe there's a parking pad on that side of the garage over there. It's the driveway to get in and out of the garage comes around there.
Okay. So you're talking about you'd have to extend the parking pad in order to access the garage in that way.
Yes.
Around that. Or you'd lose one bay of the garage and make it a 2 instead of a 3-car garage. But all of these things that we're talking about, those aren't things which are being necessitated by the forest buffer easement.
Those are, the location of them is, they can't be set further back because otherwise they would be in the forest conservation easement. They have to be located in the front, say 2/3 of the property, and there's only so much space there.
Sure, but we're only talking about 10 feet.
Correct, but there's not 10 extra feet available.
Well, there's a covered breezeway.
There's a covered breezeway between the house and the.
Yes.
Yes, But, I mean, I think
And that wouldn't affect any living space, right?
Correct, but this again goes back to, does the applicant have to build a different house than what's proposed? And the case law on that's pretty clear, that the minimum necessary doesn't mean build the smallest house possible. It means the applicant is entitled to make a reasonable and substantial use of the property. They don't need to redesign their property, their proposed building, to have the smallest thing that is humanly possible. I think what we have here is a house that is completely consistent with what else exists in the neighborhood. This is not a house that's out of scale with the neighborhood. It's designed to fit in with the neighborhood, and it's not, he's not asking for something more than what his neighbors would have. And when you talk about the minimum, what is the minimum necessary? The minimum necessary isn't necessarily the smallest thing possible. And that's, pretty clear in Becker versus Anne Arundel County.
And again, we're not talking about changing the living area of the house. And here we'd be talking about elimination of the breezeway, or shifting the garage towards the rear. You could even
I think,
turn it, couldn't you?
Turn what?
So currently, the garage is located, I guess, parallel to the property.
Mm-hmm.
If you turned it so that it was more perpendicular to the property, it would fit in that area. So you'd maintain you wouldn't really lose any of that infiltration area. And you'd have the parking pad would be extended out in an area where the garage currently is. And so you'd have the exact same garage, give or take. You'd still have the infiltration area. The only thing would be, I guess, that you'd have a further distance away from the house, so maybe that's no longer covered. But just some thoughts as far as alternative designs that don't necessarily implicate the forest conservation easement, other than that you have to operate, within that space. But
well, if I think I understand where you're going with this, I did a little bit of research in advance of this hearing today, and I found I found a case about that has very similar, maybe slightly more egregious facts than what we have. But Chesapeake Bay Foundation versus DCW Dutch Ship Island. There was a case where a property owner constructed a house, a boat ramp, and a pool on an island in the Magathie River without getting any permits. And it was a couple of years before Anne Arundel County woke up and realized it, and they then hit him with a whole bunch of citations for having built a house without permits. And there were obviously a whole series of protests from the Chesapeake Bay Foundation and others who objected to what they perceived to be illegal acts of the owner in constructing the house without the permits, and asking for these after-the-fact variances and coming with what they called unclean hands. And the Court of Appeals actually found that the failure to obtain permits or variances before construction was not at all relevant. And they held that as long as the property owner, if the property owner had a hand in creating the particular circumstances that caused the need for the variance, then the hardship would be self-created. But if the peculiar circumstances arise from the zoning restrictions themselves, then the owner's hardship is not self-created. And in that case, it was the steep slopes of the property, the soil type, and the way that the waves hit the island that were creating the practical difficulty. The fact that he had built the house already didn't matter. And the court looked at what the actual facts were with regard to that particular property, and they upheld the granting of the variances retroactively, even though the owner in that case had acted in bad faith in actively trying to skirt the permit requirements and going behind the county's back in building the building without getting permits in advance. So I think it's important to look at the property and the unique situation of the property independently of the fact that the house is in fact already constructed. Mm-hmm. And then, further to that, if we were required to move the house, I think that would create, significant expense, and inconvenience is probably an understatement for the property owner. I mean, this is probably several $100,000, if not $1 million job. They would have to dig a new foundation. They would have to disconnect all of the utilities. They would have to then physically move the house, which would involve emptying the house of everything, moving the family out for probably several months. The actual moving of the house, which is no small job, requires a lot of structural engineering, and then, obviously, like, getting everything back hooked up and getting back in there. And, I think that that's not a result that is practical or really serves, the public interest or the intent of the zoning regulations.
Yeah, I mean, as I understand the Chesapeake Bay case, that really had to do with something that shouldn't be that controversial, well, maybe it is, but that is the ability to go back and grant a variance where there's something that's already been built. You just simply look, it doesn't really change the standard.
Right.
It's either meets it or it doesn't. So there's, uniqueness and hardship and all that kind of stuff that you look at. My question really went to sort of the foundation of the variance analysis, which is that that whatever it is that's driving the uniqueness of the property has to be the instigator of the need for the variance. So here, if the property is going to be unique because of the existence of the forest buffer easement, it has to be something that arises out of the forest buffer easement that impacts the design and location of the structure. And what I'm trying to, what I'm kind of wrestling with is, well, if we're talking about 10 feet of a variance, and there are a couple of areas that are identified on the existing plat which show availability of more than 10 feet, is the forest buffer easement, or is existing in the forest buffer easement, controlling a need for a variance, or is there available area notwithstanding the existence of the forest buffer easement that's available for the location of the property? I mean, that's available for location of the structure. So that's what I was just trying to sort through.
Right, and I think, it's the forest conservation easement, it's also the location of the specimen trees, which are located in that area. They're not all shown, but one of them is specifically shown on the subdivision plat, which is the 44-inch basswood, I'm not up on my trees, but it's sort of right in the rear of the property back there that would further limit the ability of, the property owner to reconfigure the site. And there are other mature trees on the property that, as indicated in the planning department staff report, there is a need to preserve them and a desire to preserve them. And those, the location of those trees also further restricts the ability to redesign the site. And I think, what I think you're getting at is, should the zoning board be in the business of redesigning, re-engineering, a site plan when, the applicant has an expert here who has designed, the site in the way that it best fits on this property, in light of the requirements for the home that Mr. Naylor has.
Okay.
Just to, sort of continue to go through the factors that the board is required to consider. The purpose of this variance is not at all based on a desire to increase the value or income potential of the property. This is obviously an existing structure that Mr. Naylor just simply desires to utilize. The variance is not going to be injurious to the use and enjoyment of other property in the neighborhood. I think it's pretty clear, as indicated in the board's decision in January, that the 10-foot variance that we're talking about is not going to have an impact on the neighbors at all. If you push the building back 10 feet, it really is, going to have a negligible impact on the surrounding property owners. In addition, this home is consistent in terms of its architectural character with what else exists in the neighborhood, and we've included some photos of some of the properties that are located up and down the street as Exhibit 15 that shows, the materials that are used in this property and the style of the home are all consistent with what exists elsewhere in the neighborhood. And in addition, there's also a letter in the file from the owner of the adjacent properties, is Exhibit 16, the same owner owns both properties at 5717 and 5713, and that property owner who is most immediately impacted by this has no objection to the requested variance and supports the application that we have here. This is not adversely affecting any kind of urban renewal plan. This is not an urban renewal plan area, and the creation of a new single-family dwelling in this area is consistent with the city's master plan, particularly in light of the recent news story about the decline in Baltimore City's population. I mean, the city should be in the business of encouraging people to come and move into Baltimore and creating additional housing options. As I said, this variance is not going to be detrimental to the public health, security, general welfare, or morals. And again, I would point to the board's decision in January regarding the very minimal impact that a 10-foot difference is going to make for the property owners on the street. We also, I point you to Exhibit 17 in the file. We took a photograph of this property and marked it up where 10 feet would be if we were to push the building back, and you can see that the difference really isn't significant at all. You can see that it's exactly as visible as it would be given the way it is now. And again, and that picture sort of shows something that, like I've said at the beginning, we've been offering to try to do things that would mitigate the impact that this house has on the neighbors. And one of the things that we've suggested is that we could paint the sides of the house darker and that they would blend in. And I think if you look at that photograph, you can see that if it was a darker house, it might look less obvious or imposing to the neighboring properties. Obviously, we haven't gotten a lot of traction with the neighbors, but that's between that and some landscaping, perhaps there are other things that they would suggest that we could do. We certainly are open to those, but that's sort of a little bit of a digression. But I think that it's evident from that picture that there may be things that we could do to help mitigate the impact of this on the neighborhood.
I've got a question for you. We're here, we're here because of the revocation of a use and occupancy permit.
Mm-hmm.
Can you tell me the standards for the city's, in general, revocation of a UNO?
The city can revoke a UNO if it finds that the permit was not validly issued, and that appears to be what they did in this case. They found that the permit was not validly issued because a variance for the front yard setback should have been granted, and it wasn't.
Okay.
On that point, there are a couple of permits that are at play.
Mm-hmm.
You mentioned the use and occupancy permit, which was revoked by, is that Exhibit 9? Yes.
Yeah.
Mr. Rios' letter,
Mm-hmm.
he identifies the use and occupancy permit.
I note the building permit was not revoked.
Yes. Now, I think that was, yeah. Now, Exhibit 7, which was the first letter sent by Deputy Commissioner Braverman, identifies 5715 Roland Avenue, COM 2015-09124, which is the building permit.
Correct.
Our decision, which was Exhibit 8, wherein we determined that the appeal was premature, didn't state one way or the other. It just simply said that there had not been a revoked permit in this case, and so therefore the appeal was premature, and it appears that subsequently housing revoked only the use permit, but has not revoked, and the building permit, which continues in force. So given that there's a unrevoked building permit, are we to presume that the building was validly constructed, but yet now is being improperly occupied?
Well, it's an interesting question. In my view of the world, there was not any timely appeal of either permit, and I believe the board in January should have determined that the appellants were too late and dismissed the appeals of both the building permit and the use permit on that basis, and that should have been the end of it, rather than finding that there was no jurisdiction. I think because the building permit is still active and there hasn't been a revocation of that, and again, there was no timely appeal of the building permit, I think, it's within this board's authority to find that the building permit is final at this point. I mean, at this point, it's been almost a year and a half since the building permit was issued, and I frankly believe it's too late for someone to bring a challenge to it at this point. In terms of the occupancy permit, I mean, that, it does put us in a little bit of an interesting position, because if we have a validly issued final building permit that shows the building within 30 feet of the front yard, or the front lot line, how is the city in a position to say, well, now you can't occupy it? We gave you a validly issued permit. I would argue that the city really should not be, can't have it both ways.
And that was kind of my point, is that at a certain point, if there's a validly issued building permit which hasn't been revoked, and as you noted, the time for appeal has lapsed, isn't there a point in time which a property owner becomes vested with rights to build that permit, to build according to that permit, and therefore the city would no longer be able to revoke the permit?
I'm not sure that has ever been tested in the courts. I would argue that the point of having finality and the point of having an appeal period is that at the end of that appeal period, the property owner has some certainty that no one's going to come out of the woodwork and challenge their appeal or their property rights or their ability to occupy their property. I'm not aware of any case law on that, but I think that is logical.
All right.
Question. These civil drawings showing the stormwater management, these are the original plans that was subjected to site plan review?
Yes.
Just asking because it's not stamped.
Oh, I'm sorry, we don't have a stamped copy of it, but yeah, it is the one that was submitted and approved.
That's okay. Anything further?
With that, I'll wait to hear from the opposition and reserve the right to respond.
All right.
Thank you.
Council.
Good afternoon, everyone, or good evening, maybe. Well, I'm going to hit the highlights, given the hour. And as usual, I think, Mr. Washington, you hit the nail on the head in a couple of areas. And as we just heard, I'm just going to identify, or rather talk about uniqueness and also the self-imposed hardship issue. And I do have some cases that I think are directly on point on the permit issue that you just mentioned, that you may be aware of. In terms of uniqueness, two things have been identified: the smallness of the lot and the existence of this forest conservation easement. And I think your line of questioning, Mr. Washington, was exactly what I wanted to do through our expert, Chris Jakubiak, who unfortunately had to leave, but he's a planner. And I think you hit the nail on the head when you said that this entire thing, the house, the covered breezeway, and the garage could all be moved back 10 feet or more and not even touch the forest conservation easement, not even touch it. And I'm referring specifically to the tab 6 in the property owner's exhibit binder. Although there's not a distance on this particular plan between the back of the garage and the forest conservation easement, I mean, you can just compare it to other areas on the plan which are 10 feet or more. For instance, above the garage that is on the north side, there's a 15-foot private sewer connection easement. That it is clear to me, at least looking at this on plain view, that there is more, at least 15 feet, if not more, behind this garage, that the entire thing could be moved back. As you were just saying, I don't even think you need to get rid of the covered breezeway. I don't even think you need to reduce the size of the garage or the numbers of cars in the garage. And in terms of I understand the argument about the stormwater management, the existence of that facility there. There's been no testimony today, and I think it would require some expert testimony that couldn't be moved anywhere else, because stormwater management's like that. You can move it elsewhere. And number two, as I think you pointed out, sir, about the location, or maybe
Mr. Barb,
yeah,
I believe.
about the location of the forest conservation easement. The garage could be moved back without touching, not the forest conservation, I'm sorry, the stormwater management area. The garage could be moved back without touching the stormwater management area. And it's without, again, without adjusting the size of the house, the size of the breezeway, or the size of the garage. And that may require some, some adjustments to the parking, to the driveway getting into the garage, but so be it. But in my experience, and I'm not an expert in stormwater management, but you can adjust a stormwater management facility. There's no reason, in my lay opinion, why you couldn't move the easement so that it is more along the southern border of the property and not in the back. There's a reference to specimen trees. I know what specimen trees are. There are none. If there is one, I didn't catch where Carolyn said it was, but if there are any in the forest conservation easement, that doesn't change the analysis because it's either going to impact the easement or it's going to impact the trees. But if there is, let's say there's a specimen tree right in the middle of this property, beyond, before you even get to the forest conservation easement, there are variances you can obtain to destroy a single specimen tree. That's done day in and day out. I know that for a fact. So that would be a far lesser variance. And by way of example, the garage, even if we don't talk about moving the garage straight back, we could also put the garage in the side yard or a smaller garage, and you could obtain a variance for that, as you know, Mr. Washington. That's a lesser variance. I don't frankly agree with the argument that the smallness, either the smallness of the site or the existence of the forest conservation area or its specimen trees create the uniqueness. In fact, I would refer the board to the standard itself, which talks about, this is 15-218, which talks about what it is about the land that needs to be unique. And it says, because of the particular physical surrounding shape or topographical conditions of the specific structure or land. And I would submit that in particular, a stormwater management facility, a man-made facility, is not a physical surrounding shape or topographical condition that you could even argue would be a impediment to warrant a variance. Perhaps a forest conservation easement is, but again, that is that's not a natural thing. That's a written document that's recorded in land records that requires the property owner to take care of that area of the property and not to destroy it. I'm not so sure that's a natural feature that is what I think 15-218 contemplates. In any event, I'll move on from there. In terms of the self-imposed nature of this hardship, there are a number of things, and I don't want to put on into the record any evidence that's already there, rather. And so I'm going to avoid doing that. The only thing I would maybe put in is this packet of documents, Mr. Washington, which I'll hand to the board if I could.
Sure. If you have a copy for council.
I do.
And I think you'd referenced the location of the specimen tree. I think
Yeah.
Ms. Hecker had indicated that that's reflected on Exhibit 2, and specifically on the plat, there's indicated a 44-foot basswood tree.
Oh, I do see it. I apologize. Yeah, I do see it. And given the location of that tree, it may or may not be in the stormwater management area, but it doesn't look at all to be in the, well, it may be in
Well, I think it's in the...
forest conservation area.
Yeah, it's not in the forest conservation area. I think if you overlay it with the stormwater management drawing, that it would be located within that area. Is that correct, Ms. Hecker?
I believe that's correct.
The area outside of the forest conservation?
That's correct.
Yeah. And I don't disagree with that. That looks to make sense to me. My only point there, again, Mr. Washington, is that that's a variance that can be obtained if you can't build around it. And I'm not sure there's been any testimony or evidence today that they couldn't work around that, particularly the stormwater management area. So anyway, what I've handed up is just in a nutshell is some of the evidence that we believe supports the self-created hardship that's involved here. And I know the board is fully aware of all these facts, but nevertheless, the first page is obviously the building permit itself, and it says as per plans in addition to as per code. So all of these things, everything in this small handout here, we believe put the property on notice, or at a minimum, should have put him on notice of the existence of not only the code itself, but also the larger setback in the subdivision plat. So for instance, the deed, which is the second page, second, third, and fourth pages of this document, makes specific reference to the final subdivision plat, which contains the larger setback, Mr. Washington, that you were referring to. So, so we also have attached, there's another copy, already part of the petitioner's case, the final subdivision plat, as well as the final development plan, which is the last page. So the fact, that's number one. I know that relates more to the 82-foot setback than the 40-foot setback. But with respect to the 40-foot setback, I think it's common knowledge, if not certainly knowledge within any attorney's purview, that a mistake of law, a mistake about what the zoning ordinance does or does not provide, is not a defense. It's simply not. And I would also submit that a mistake of the planning office. The planning office, I do not disagree, made perhaps two mistakes. I think the evidence supports that. The planning office made a mistake in allowing or telling perhaps the property owner that this is a 30-foot setback and not a 40-foot setback. I think the evidence probably supports that, and I think that's what the property owner would say. And the planning office also made the mistake of not recognizing that the subdivision plat, which is on file in the Planning Commission's office, had this additional 82-foot setback. So those are mistakes that I think are supported by the record. But the law is also clear, and this is the law that I was referencing, Mr. Washington. I have a couple of cases that are much more on fours than the Chesapeake case, which I'll talk about in a minute. I think you distinguish the Chesapeake case from this one rather easily. But these cases all involve, and I'll cite them for you in a minute, I have copies for you, all involve cases exactly like this. That is, where the city issued a permit by mistake. A clerical mistake or otherwise. The permit was issued by mistake. In at least a few of these cases, the property owner began construction of either an ice house, I think was one, a dwelling, in specific reliance on the issuance of that permit. And then when the city or the town, whatever case it is, realized the mistake and asked the property owner to account for it, the property owner argued in each of these cases usually two things. Number one, that he or she was vested, just as counsel was talking about, by virtue of the issuance of this permit. Well, the law on that, in these cases, will tell you, and I'll read from one in a second, will tell you that nothing vests until if there is only if there is a valid building permit. So even in cases where it's retroactively determined that the permit was issued invalidly, for purposes of vesting, even if it's 5 years later, nothing vests if the permit was issued in the first instance by mistake. And the second argument that these cases address is the zoning estoppel. That is, that the municipality is stopped from relying upon the invalidity of the permit because the property owner relied to his or her detriment in doing whatever he or she did, including construction of something. And the courts again reject that theory in these cases. So I have copies for you.
So it's your position that the appeal rights that Ms. Hecker spoke of haven't run yet. The appeal time hasn't run because of the invalidity of the building permit.
Correct. Yeah, that's correct. But the permit has to be valid in order for, and I think we probably all remember from law school, or maybe not, but certainly people that do work in this area, the two general common law requirements for vesting are a valid permit and substantial construction. A valid permit means one that is legal, regardless of when it's, it has to be legal and final. So those cases, I can cite them to you, or I can give you copies, whatever you prefer, Mr. Washington.
Sure, if you want to hand them up. Now, the applicant argued that, and Mr. Bonaventure was just raised this issue as well, that the that I guess your client didn't take a timely appeal of the issuance of either the building permit or the use and occupancy permit. And so therefore, your client can no longer take or seek any redress for the issuance of that permit. So I'd want to find out what you had to say on that, and then as well as whether or not there's a ability by the city, independent of that, to nonetheless revoke the permit on its own.
On the latter, I would think yes, because again, the municipality has that ability, once it discovers that a permit was issued by mistake or an error, that it has the ability to do that. And I think these cases support that. I said I was going to read, maybe I won't read to you, but these are the cases. Let me give them to you before I address the second issue.
Thank you.
And I can give you those sites. With respect to the timing, Mr. Washington, of the appeals, I'll be honest with you, I was not involved in them, and frankly, I don't have the factual background in my head to discuss that. It wasn't a thing that even occurred to me, frankly, before I came here, so I'm not going to be able to address that. I would note one thing. There was a question about this letter from the city about whether this was constituted a revocation or not. But the letter itself, as I read it, says that the permit, this is the tab 7, property owner's binder, September 26, 2016, says that the permit was issued in error. The error made by the city, et cetera, et cetera. There's no reference to revocation in here, but in terms of, at least in terms of the vesting argument, that, and as far as the city's concerned, I think, to me, that says that the permit's not valid.
But I think that the thing that we were looking at there was that there's nothing, as you pointed out, there's nothing in the, though the letter does point out that there was an error in issuing the permit, it didn't propose any action or state any action that the city was taking by reason of that. It simply said, well, there was an error.
Well, I think the action it took was, it's because the permit's invalid, it was issued in error, there is a nonconformity, and this is the action it took, must apply for a variance. That's the action it took.
Okay, so you'd say that in this case there was a revocation of both the building permit and later of the use and occupancy permit.
That's what I would say.
Okay.
That's what I'd say.
Do we have those other cases?
Yeah, you want to say?
David has.
Just a couple more points, Mr. Washington. And I can provide additional copies. And I was a little troubled by the reference in the board's prior opinion about the validity or the binding nature of the subdivision plat. The only thing I wanted to point out in that respect, and I know it's indirectly relevant to this proceeding because we're here on the 40-foot setback, but I think it is relevant to self-imposed hardship. That is, did the property owner know that there was even a greater setback, and should he have built the house knowing that or with notice of that? And what I would point to the board on that issue is the subdivision ordinance itself says, and this was in both the prior version as well as the one that's effective March 31st, 2017, it talks about the subdivision process, and it says a copy of the approved final subdivision plan will be retained in the Department of Planning for verification of compliance on subsequent building permit applications. So the subdivision plat may not be like a recorded covenant. There's a whole other issue in this case about this covenant that council addressed. But the subdivision plat, separate and apart from the covenant, is something that's supposed to be retained by the planning office and supposed to be verified to determine compliance before a building permit is issued. I think there was a mistake, admittedly, on the part of the planning commission or the planning office not to verify as the ordinance provides, but I think there is something binding about this. In other words, I do not believe that assuming this board were to grant this variance, that the property owner could turn around and go ahead and be permitted a building permit and a use and occupancy permit. The subdivision plat is violated. It's inconsistent with the building permit. And it may not be binding as far as this board's concerned. I would agree with you that this board has no authority over what the subdivision plats and what the planning commission does. But it is binding nevertheless. So I just wanted to point that out. Let me just quickly, and I know other people are anxious to talk. I want to be careful because I know you wanted to hear profits from council, and there was a statement that it's going to cost $1 million to move this house. I don't think that should be accepted by the board as a proffer. I think we need evidence of that. That's a big statement. That's a big number. It sounds big to me, but
My recollection of the testimony from December was that I think that there was a building, I think, moving.
House moving company.
Yeah, house moving company who testified, and I think that they even put forward a quote, and I think it was like $230,000.
I think it was $34,000 for the moving, and I think the.
And I had asked him what the cost would be.
And he guessed. I think not guessed. He estimated. Yeah. Because he wasn't asked to do that by us. We just asked him to determine how much it would cost to move it. So $34,000 to move it, and perhaps, a bit more, substantial bit more to redo the foundation. The other thing about this this policy, I would note, council indicated that there was nothing in the policy about the plat, and there is. In Schedule B, exceptions from coverage, under paragraph 8, it says, subject to the easements, restrictions, conditions, setback lines as set forth in the plat entitled Final Subdivision Plat, 5713 Roland Avenue, with the reference to land records reference. So yet again, in addition to everything else we've cited, which is this packet, further evidence, I believe, that the property owner knew or should have known about the existence of the larger setback, let alone the knowledge of what the ordinance does or does not provide. None of which, by the way, I would just close here, and I know I've spoken a long time, none of which makes a difference in terms of these cases are concerned. It doesn't matter whether he knew or didn't know about the code. It doesn't matter whether he knew or didn't know about the subdivision plat. It doesn't matter whether it would impose some hardship on him, or whether, I think that the theory by council was, we have the right to build a reasonable house. No, you don't. Not if the building permit was invalid, and not if the setback is violated. You don't have, that's not a right independent of these arguments. So with that, I'll let Mr. Scher speak. And thank you.
Thank you. I think that Mr. Buchanan has done an excellent job, and I don't have much to add except that this case seems to fall within a classic violation of Cromwell versus Ward, where Judge Cathell held that you can't create your own hardship, and you can't, and the fact that a permit was issued after the fact, the variance can be revoked and cause the applicant to take down the house or to move the house or to otherwise move the structure. And there are a whole line of cases that it's Cromwell versus Ward and its progeny. And other than adding that, I would rely upon what Mr. McCann has done.
Thank you.
I think we're going to try to streamline things. And I'm going to ask everybody to make a decision on their own who needs to say something. And I will ask my client, Ms. Taylor, to come up.
All right.
And then beyond that,
I'd like to say thank you to the board, thank you to the chairman, and I will keep this brief. As you know, we are respectfully requesting that the variance be denied to allow the case to proceed to the pertinent city agencies to enforce the 82-foot minimum front setback, which is clearly specified on the final subdivision plat, or at least to comply with the 40-foot setback, which is clearly specified in the zoning code. The building permit was issued in error, as we know, by Mr. Charles Lee. He failed to consult the final subdivision plat and the covenants, which were clearly on file with the city's planning department records. And those covenants, by the way, were arrived at after intense community discussion and negotiation, which allowed for the initial creation of the subdivision. And the reason why I'm concerned is that the house does stick out like a sore thumb, being so close to the road compared to all the other homes, which have very large, approximately 100-foot setbacks. And we do have an exhibit for you to show that. And it reduces my property value, and it is a violation of the city's zoning regulations. So the remedy that we're requesting is to move the house, and as expert house movers testified previously, the cost is approximately $34,000 to move the home. They said that the home, once the new foundation is poured, could be moved in approximately 1 week, that the family can continue to live in the house. They might need to vacate it only for a 1 or 2 day period. We do actually have a petition from 15 other neighbors asking for the same remedy. The only property owner in the neighborhood who supports the home to remain at its 30-foot setback is Ms. Carl, who sold Mr. Naylor the property. And she also signed the covenant. And I'd like to thank you for your time. Thank you.
Just for the record, state your address and your full name.
I'm at 5801 Roland Avenue, and my name's Angela Taylor.
And how many doors down? From
I'm 2 doors down. Thank you.
Let me ask you a question. We saw a drawing or a rendition of the house. Let's assume, just for purposes of argument, that we find that this house should be moved back 10 feet. We saw the rendering of what it looks like moved back 10 feet. It doesn't appear to me to have that much of an impact upon your sight lines. What's your position on that?
I think I would benefit from the home being moved, absolutely. Thank you.
Okay.
Mr. Chair, just a quick comment on the testimony about, from the expert home mover. It was my recollection from that testimony at the last hearing that was woefully inadequate as far as the cost projections. He had referenced only something about the foundation itself. So I just want to make sure we're not stuck on a $34,000 amount when I have a feeling it's a lot more than that.
Yeah, as I think Mr. Bonaventure pointed out, that that cost was independent of the cost, that was just the cost of moving. That wasn't the cost associated with building of the foundation and the various different connections that would have to be undone and then redone to be able to have a functioning house. So I agree that that $34,000 was the cost for moving, but wasn't the all-encompassing cost of what the job would in the end cost.
In fact, I would agree that he wasn't even qualified. I think what he does is he moves houses.
Yes.
I think he acknowledged that he wasn't the guy that comes back in and does the foundations and so forth. But my point simply, and I know this, which is why we didn't put on much evidence about that at all, Tate, that it doesn't really matter, frankly, the cost from this board's perspective. I'm saying, of course, it matters to other folks, but from this board's perspective, I don't think that matters.
Yeah, and I think that was Mr. Scherer's point by referring to the Cromwell case.
Ms. Taylor, could you elaborate a little bit more on how you would benefit?
My home value would be partially restored. I assert that my home value has been decreased or diminished by the construction of this home so close to the road because it's not in keeping with the neighborhood for it to be so close to the road compared to the other homes which have approximately 100-foot setbacks, which is why the covenant was drawn when the subdivision was created to prevent this from happening. And we do have letters from 2 realtors to attest to this in the previous testimony.
And you think that a 10-foot move would restore value?
Partially restore.
Anybody else? Gentlemen? At least identify yourself and your address, and then if there's anything you want to say that hasn't been already said.
Yes, my name is Matt Hodson. I'm at 5908 Roland Avenue, and I'll make just 2 very quick points. There were 2 issues that I don't think were a fair characterization of the history of the issue. One was that this house was designed and constructed to be in keeping with the surrounding community. I think even the layperson in looking at the pictures and designs and plats and setbacks can see that it falls very short of that, in my opinion. The other issue is one of timeliness. The comment was made that there is some limit of time in which the community or anyone could raise an objection about the property. And the reason why there was not an earlier objection was that there was no forum for an objection. The hearing for variance never occurred. There was no application for variance. There was no notice to the surrounding neighborhood. And as from what I know, there had been really no overture to the community to discuss the issue at all until the issue fell in your lap late in the fall. So
I think the issue was there's a procedure where you can appeal a permit.
Okay. Yep. But we did not know about the issue and did everything in our power as fast as we could to make the community's objections known, and there was no response.
My name's Norman Howie. I live at 5807 Roland Avenue, which is 4 houses down from the construction. I just wanted to comment on 2 things. One regarding the uniqueness of this property based on its size. I have one of the smaller properties in that neighborhood, so I think the number was 18,000 square feet. My property is 20,000, 21,000 square feet. I have a 5807 Roland Avenue, directly on the corner of Roland and Lake.
Okay, I was going to say, that was the one that kind of jumped out.
Yeah, that's it.
You're right there.
That's me. And I have somewhere between a 90 and 100-foot setback, a 4,000 square foot house, approximately the same footprint. And of course, as a result, I have a small backyard and a single garage, but a very large front yard. And the second comment I wanted to make was just sort of to reiterate how this stands out like a bit of a sore thumb in the neighborhood. So of course I have an old style Tudor house, stucco, followed by stone house, followed by a brick house, followed by a brick house, followed by Mr. Naylor's, and then several Victorian houses, all with a 100-foot setback. So at least on this block, this one house is quite distinct.
In terms of style?
Quick question.
In terms of style.
Do you have a forest conservation easement?
I do not. I do not.
Okay. And the codes after your house was built are different with respect to the stormwater management?
I would assume so. My house was built in 1928.
In terms of style, real quick, do any of the homes you mentioned have this sort of siding on the side? Or?
None.
Okay.
No.
Okay.
Thank you.
Another question. Are there any 3-car garage homes in the neighborhood?
Not that I'm aware of, no. All right, thank you.
At least identify yourself, just for the record. Okay.
Hi, this is Dan Taylor, 5801 Roland Avenue. So you don't count us twice. I'm Angela's husband. The one thing I wanted to add is that the main area of concern for me is that a requirement and what led to the subdivision of the property in the first place was through extensive negotiations with the neighborhood about a setback of 82 feet and required building materials. I don't believe, I wasn't there in 1999, but I don't believe the subdivision would have been approved in the first place if not for that covenant. And I'm having a lot of trouble understanding why that covenant wouldn't be enforced. And if it's not enforced, I'm not sure how that would prefer for other properties in the neighborhood in the future. And so I just wanted to express my concern there.
Thank you.
Good evening, Stuart Serena, 5909 Roland Avenue. I just want to make one very narrow point.
Say that last name again, sir.
Yes, Serena, S-E-R-A-I-N-A. One very narrow point. Stuart, S-T-U-A-R-T. Counsel made the point early in her argument that from looking at some of the pictures that have been provided to the board, that from the north, the problem, that the appearance of the house is obscured by trees. That might be true from an aerial photograph, but it should be clear to the board that that's not remotely true from the street level. And when you drive south on Roland Ave, one of the most prominent things that comes into view is the Naylor's home, its side, and in particular its HVAC units, which sit very close to the street. A 10-foot additional setback would make a material difference in that view.
Thank you. Can I ask a question? Mr. Washington, is the record on this case, it's obviously different than the record in the prior case? The records aren't joined in any way? Is that-
We still do have I mean, obviously, the board heard that testimony. It is in our recollection. We've talked about it here. And it is amongst the board's files, and we certainly have the ability to take notice of that, so.
Okay. I'm just in
If
terms
there's
of,
anything that you're wanting to put forward to make sure that, so that I will imagine that there may be subsequent proceedings concerning this case. And so if you want to make sure that there's something which is within the actual record taken on this day, you can certainly, we're certainly understandable of that, and you can put that forward.
well, I will do that then. Just two things, and I don't need to give everybody copies. I'll give one to council, but these were introduced below. These are email notifications or email communications with the planning office about before the construction began, asking about the setbacks. And this is the cover letter and the covenants, which you have a copy of, correct? Yeah. So this may already be in evidence.
Okay.
And that would be it.
All right.
Thank you, everyone.
Ms. Hecker.
I'll be brief. I know we've all been here a long time, and I know you're not even close to being done for the evening. So I'll be quick.
We have a whole nother docket.
I know. And you have my sympathies. But I think there's sort of two separate issues. There's a substantive issue and then there's a procedural issue. On the substantive end, this is an application for a variance. I think we have put forth evidence that the property is unique by virtue of its relative small size compared to other properties in the area, the existence of a forest conservation easement that uncovers the rear third or so of the property, the existence of specimen trees, which are specified in the planning department's report. There's a list of the specimen trees that are located on the property that limit the ability to construct the house. All of these things create a practical difficulty for Mr. Naylor in siting the house on the property. And we would be applying for a variance whether the property was vacant now or the fact that the building has already been constructed. And these unique features of the property are what create the practical difficulty, not the fact that the house is already created. On the procedural end, there was a statement made a little while ago about, in order to have vested rights, you have to have a validly issued permit and substantial construction. And I think you've raised an interesting question about whether or not the building permit is a valid permit. And I think the building permit is a valid permit until the city says it's not, and that hasn't occurred in this case. And
there was
there's a letter,
Mr. Braverman's letter, where he did say that it was an error.
He said it was an error.
He didn't say necessarily that it was revoked. That
and in fact,
word isn't in there, but he did at least say that it was not a valid permit.
That's correct. And in fact, this board found in January that permit was not revoked and that it was still valid. And that was why the board dismissed the case.
Found that. I think that we expressed an opinion about how there hadn't yet been a revocation.
Well, if there hadn't been a revocation, then presumably the permit would still be valid.
Sure.
And so there has to be some finality for the homeowner, is my point. That if the permit is validly issued, it hasn't been revoked, the time for filing an appeal has come and gone a long time ago. We have a situation where the homeowner needs to be able to have some comfort that someone's not going to come out of the woodwork at some point and challenge their permit. And that's why we have these appeal periods. And I note that they handed up a copy of the email correspondence with the planning department.
Still, I mean, apart from the appeal right that an aggrieved citizen might have for the issuance of a permit, the city would still be, as any municipal authority, would be within its rights to subsequently revoke a invalidly issued permit.
Correct. Which is what they've done with regard to the use and occupancy permit here.
Sure, and so we could leave here today, and they could, maybe if he was watching on the streaming website, could come down and deliver a letter to you saying, yes, your permit is revoked today. So there's a question as to whether or not that could legitimately occur. I think it probably could, to the extent that it hasn't already. So there's sort of two things there as to whether or not The city still has the ability to revoke a permit once the appeal period has run, and whether or not the opposition, despite the fact that they didn't take a timely appeal, can still be opposing the issuance of your permit. So it's sort of two different.
Well, I mean, I think, for better or worse, I think it's clear that the city could revoke a permit after the end of the appeal period. But I think the city has to take an action to do that. I don't think that the complaints of several neighbors act or operate as a revocation. I think the city has to decide to revoke a permit. And I think, in this case, the city did that with regard to the UNO permit, which is what brings us here in the first place, which, gets us to, this question of, should we be entitled to a variance? And I think, we've put forth a case explaining why we should be. And just to respond, I haven't seen the cases that council handed up, but I understand that they relate to zoning estoppel. We're not arguing that the city is stopped in any way. I understand that the state of Maryland has not adopted the doctrine of zoning estoppel, and this, there's no basis for us to argue that the city has to do something in this case based on our reliance on the validly issued permit. I think our point is that we would have needed a variance regardless. The fact that the house is built already doesn't really have any bearing, and the property is unique. The unique factors create a practical difficulty, and a variance is warranted as a result of that.
Okay. Dave?
That's it.
All right, thank you.
Thank you all.
Thank you all.
Thank you. Thank you.
Let's see. Probably not two other cases. Grundy, and we've got West Lafayette.
There's Preston back here.
We can jump over that one.
We've still got a vote while I'm here.
Get him through here. Calling 2017-81, 1201 through 1203 East Preston Street. Alexander Lee McKenzo.
My bad, Grundy.
I haven't seen him here all day, actually. Calling again 2017-81, 1201 through 1203 East Preston Street, Alexander Lee McKenzo. Was he here previously?
I answered the call previously.
I didn't think that I saw him. All right, calling 2017-68, 719 Grundy Street, Ken Sikora.
I'm stiff from sitting too, so don't feel bad.
She's 98.
I'm only 98.
I actually would not have thought anything over like 75, but you look fantastic. All right.
Gone 59 for the record.
I guess I can't go back and say. All right. Mr. Prettle, we have this as an application to construct a two-story rear addition with side stair landings and rooftop deck. Is that correct?
That's correct.
All right. If all those intending to give testimony can raise their right hands and be sworn, please.
That you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
All right. Do we have staff reports?
Primarily, we have a letter dated Monday, March 27th. As you know, Baltimore has a wonderful diversity in its neighborhoods, not just the named neighborhoods, but block to block. You will find unique features and styles that are a point of pride for the people living there. For 3 blocks on the east side of Grundy Street, we have a series of lots marked by relatively large backyard areas. The residents' use of this space in their own way, sometimes just as a parking pad, but often for lawns, gardens, personalized to their tastes. Another unique feature, thanks to the slope of the hill here, are the modestly sized first-floor decks. From these, we can interact with our neighbors, whether they're out for their morning coffee, hanging out with friends, or just enjoying the good weather. These features have worked wonderfully to improve our relationships with the neighbors. They encourage a sense of community by creating an area for the residents to showcase their style and participate in the neighborhood. The broad sight lines caused by the minimal barriers discourages crime. All in all, this community has created something that is hard to find in Baltimore, and while it may not fit everyone's needs, I am proud to say that I live here. The builder, property owner, has seemingly paid no attention to what makes this neighborhood so special in their plans, choosing instead to build a wall through the middle of it. They have not been shy about their motivation for profit in their communications with the neighbors, and their other decisions have shown general disregard for the lives of those living here. They took no care to limit the spread of debris into the neighboring houses during the demolition phase, a problem which we are still cleaning up a month after that work ended. They have lied about statements made by neighbors as if they don't realize that we talk to each other. The interior of their house was in dire need of repair when they bought it, and I am certainly not opposed to those upgrades. However, any changes to the exterior profile of the house have marked ability to affect the rest of the community, positively or negatively. I would like to see changes that the work to improve the community we have, not take away from it. Attached with this letter is a petition with 30 names in opposition, and there's a letter from the Brewers Hill Community Association. They write that the Brewers Hill Association is opposed to the proposed variance, in addition to not meeting the requirements as outlined in Title 15-209. If allowed, the variance will impair an adequate supply of air and light to adjacent properties, be injurious to the use and enjoyment of adjacent properties in the immediate vicinity, diminish the property value of adjacent properties, increase the potential of crime and or illegal activity, diminishing or eliminating existing site neighborhood lines, and is contrary to the public interest. I believe the opposition they have supplied a stack of photographs as well, but I believe they're going to give you those.
Actually, I can just give everybody a copy real quick so we can all.
And that is the end of my report.
I'm sorry, I apologize. Did I jump in line?
Well, it's just, I got to keep.
Yeah, he just needs to know who you are when you speak, that's all.
I need to move it 10 feet. No, sorry. I'm Jack Young. I live at 715 Grundy Street.
Obviously not the
I'm
council
one house
president,
away
right?
from 719, where Mr. Sikora and the appellants are trying to expand their property. I'm handing these out because when we get to the point where we're going, did everybody get one? No, you did get one.
I do have it. No.
No, you don't have
Yeah, I
the
do.
color one. Oh, you did, my bad. Did I forget somebody? Did I get it ready? Okay, here you go. So, when we get to our point, it'll just help things. Came off. Just so we can go through it and hopefully not take so long.
Okay. Thank you. Mr. Prado.
Good evening. Nate Predel, AB Associates. I'm here with Ken Sakura. He's the property owner and builder. I'm going to try to be as concise as possible due to this late hour. My client's proposal is to build.
Just a moment, Mr. Prado.
Yep.
Mr. French, was there anything for the planning department?
Planning Department has no comment on this application. Thank you.
Thank you.
All right. Good?
Yes.
Okay. My client's proposal is to build an 8-foot wide an 8-foot deep by 11-foot wide addition at 719 Grundy Street, which is in the middle of the block. The reason we're in front of the board right now is solely because of the non-complying row house provision of the zoning code, which is found in section 13. A little bit of history. Mr. Sakura received a building permit for the work that is in front of the board today. He went through the non-complying row house provision, which was enacted several years ago to allow, certain smaller additions, many of which require variances to go forward without a zoning board hearing. As part of that, afterwards, there was some letters written to the zoning administrator by, I assume, these neighbors here, saying that he did not complete one portion of it, which was there's registered letters that need to be sent to adjacent property owners, and he sent those but did not include the plans. Based on that, the zoning administrator referred this to the zoning board. So we're here today for this small addition. What we're not here today for is any sort of zoning variance or relief from the zoning code. This proposal meets the lot coverage, setback, height, and so forth, all of the bulk density. There's a single-family dwelling, all the height, bulk, density regulations of the zoning code. In fact, if the proposal were to be granted, you'd have a lot coverage of approximately 51%. The R8 zoning district prescribes no more than 60%. He would have a rear yard setback with the addition of around 38 feet. There's 46 right now. That's well over the 25-foot required yard. I briefly had a chance to look through this packet that the neighbors submitted, and I think there may be a little bit of confusion about what Mr. Sakura is seeking here, because in no way are we seeking any variance from the zoning code. There's a lot in there that talks about the required findings, uniqueness, hardship. We're not seeking that at all. The only reason this property is non-complying and even here at all is because of its 15-foot dwelling width. The zoning code prescribes no new structure to be built less than 16 feet, but that does not count pre-existing buildings. If you were to look in Brewers Hill, Canton, as all of you know, I'd say 90% of the buildings are less than 16 feet. And I would point to section 3-303 of the zoning code saying the subsection does not prevent or restrict any otherwise lawful expansion of a lawful pre-existing residential structure that is always 16 feet wide. That's what we're here for today, is a request for a lawful expansion of a lawfully existing non-complying structure. And I think I would just probably leave it for any questions for you and to be able to respond to what the opposition's saying. But again, we're not seeking any zoning variances whatsoever.
Okay. We have a difference of opinion. If you look at the packet, I'm just going to walk through this, and if you go to page 2 of the packet, what you will see in the orange dotted outline is the shape of every house, all of the 20 properties that sit on the west side of Grundy Street. Now, the uniqueness about this property is we do have a longer backyard because those houses were built in 1929, long after the houses across the street were constructed in 1915. If you look at this drawing, in orange, you'll see the deck, the existing deck of Keith Henry, who is one of the adjacent property owners at 717 Grundy Street, and luckily I have Ms. Wasinski, who's also the other adjacent property owner at 721. If you look at this drawing, you'll see in that shaded area, right to the left of where the man's standing, you'll see the proposed addition. If Keith, this man standing right here, was standing on his deck, then what he would see, if you flip to page 4, please, and look on the lower left-hand corner. If you look in the lower left-hand corner, that's exactly how much Mr. Sakura's structure would inhibit Keith's view. Now, if you look up at the top of this picture, I took these pictures this morning on page 4. On the upper left-hand corner, you see Mr. Henry's deck, and he is at 717. Then you see a little deck on the other side of the red house. The red house is the house that Mr. Sakura has purchased, and that's Loretta's house. She has a deck that I guess is about 3 feet. Then if you look the other way, you can see all the way down the street, every house on this block has the exact same rear wall. Now, the benefits for that is that what it helps us basically meet, and I'd like to go to page 14 of the Baltimore City Revised Code, Title 15 Variances. On page 14, the reason I have those here is because highlighted on page 14 and highlighted on page 15, it states that the board, to issue a variance, that this very board here must make sure that that variance is not injurious to the use and enjoyment of other property in the immediate vicinity, which this does, substantially diminish or impair property values in the neighborhood. This would substantially diminish property values because Mr. Henry's porch and mine, there'd be a wall there. It'd be like a fort.
If I can interject, I think we're on the same point.
That's okay.
Are you contending that there's a variance that's being sought?
No, I think no.
I think what's happening here is, and I may not be clear about this, but I think they're trying to expand a property that's going to be harmful to this neighborhood.
Okay. So just to back things up a little bit, and try to sort of explain where things are. So there is, I'm looking at the drawing here that's attached to our data sheet that has all the, not all, but many of the papers that are filed with zoning plans and with building proposals. And so what that reflects is that 719 Grundy has, it's on a lot that is, if I look at my tax map, that'll tell me.
A copy of the block plat. This helps to share.
Thank you very much, Mr. Bro. All right, so it's 96 feet in depth and 15 feet in width, okay? And what the zoning code says is that there are certain requirements that are imposed with regard to setbacks, building heights, things like that. And you heard a lot of that play out in the case that was before you.
Sure.
And here, 719 Grundy, it's got an existing porch that's like 9 feet long and 10 feet wide, and it's got an existing building that's 29 feet.
Well,
and then it's got the proposed addition here that's in the back, and then it's got a rear yard. And what our record shows as far as the requirements are that lot coverage, that's one of the things that's at issue, is how much of a lot can be covered by a structure. And what we have on that is that the maximum percentage of a lot which may be covered by structures is 60%, okay? So you can't cover any more than 60%. The existing structure right now covers less than 31% of the lot. But they can still build up to 60. So according to the appellant's documents, the proposed additions and decks will increase the lot coverage to not more than 58%.
Right.
So they're
That's
building.
a little bit off what we have, but it's fine.
Sure.
Still under 60. so
That's
whatever.
okay. So they're within the lot coverage restrictions. And then you move to rear yard, because that's another thing that often comes up in these kind of cases where you have someone who's, the zoning code will require a certain setback from the rear line of the property, so that the intention there is that, you know, they want you to have a certain amount dedicated to rear yard that's not covered by structure. Just the same as in the case before you, there was a lot of discussion about front yards. This is just a backyard.
Right.
So rear yard of not less than 24 feet in depth is what's required. The existing structure retains a rear yard of not less than 56 feet deep. And according to the appellant's documents, the proposed rear addition will retain a rear yard of not less than 37 feet deep. So the requirement is 24 feet, and they're retaining 37. So they're retaining more rear yard than is required.
I understand.
And they are covering less of the lot that's required. So they're not seeking a variance of any of those things. As the appellant pointed out, the provision regarding expansions of structure is something that comes into play here. And there that says that notwithstanding subsection 13506, which is restrictions on expansions, an attached or semi-detached single-family dwelling that is non-complying, that is a non-complying structure. Here it's non-complying because the building widths are required to be not less than 16 feet, and this is 15. Right. So single-family dwelling that is non-complying may be expanded so as to, one, increase lot coverage that existed when the structure became non-complying, that would be when the zoning code was enacted, by not more than 10 feet of that lot coverage, 10% rather, of that lot coverage, and decrease the rear yard setback that existed when the structure became non-complying by not more than 2 feet. So that provision there, it provides for a waiver of those of any kinds of restrictions on expansion, but does not recognize those as requesting any kind of variance.
Okay.
So, and the standard there is basically it allowed for approvals of these kinds of structures on a more streamlined basis, more as I think more as a conditional use than as a variance. The idea being that for these kinds of expansions of non-complying structures that really don't implicate the required setbacks or lot coverage or anything like that, shouldn't really be held to those same standards. And that's why it is here in front of us, as indicated by the zoning administrator's decision, because of an issue regarding compliance with that, with the procedures identified under that provision of the code for for expansions of non-complying structures. So the arguments regarding the standards that apply to a variance really wouldn't be at play when you're talking about this kind of expansion, because they're not seeking a variance of lot coverage.
I understand.
Or setbacks or height or those sort of things.
I guess where I go to, and my neighbors can also speak to this, is what will happen if you allow this to happen. Mr. Sikora doesn't live here. He does not pay taxes here. He doesn't vote here. He's a developer, and good for him. He's going to make money, and
Well,
he's trying.
He probably does pay taxes if he owns the property of his.
Well, you do pay taxes, but he doesn't live here. And in about, I'd say probably in 6 months or 3 months, however long your construction schedule is, however long his construction schedule is, he's going to be gone. You're talking about a neighbor. Loretta has lived in this neighborhood 69 years. And all the people standing here, when the Great Recession was in process and you couldn't sell a house in our neighborhood, there was no people like Mr. Sikora there to protect it. It was these folks. And I think it's incumbent on this board to do what's right for the people who live in this city, who work in this city, and also who pay taxes and vote. But you're talking about what he wants to do is he wants to add like 8 feet to his house to add a laundry room. And while I appreciate that, I think there needs to be some weight put into this situation about the neighbors. We had, and gentleman and lady, well, she's left, we had 30 people sign this who live on Grundy Street. Do you realize what a task that is? Think about that. And I think if you look at the issues, and I don't need to talk too much longer, but if you look at what he's doing here, it will block literally the whole neighborhood. And so if you approve this, then what you're going to be in essence doing is what interstates did to city blocks. You're going to be dissecting this neighborhood, which has functioned well since 1929, with somebody who is going to make an investment and in a couple of months get the investment and leave. I think you have a greater responsibility to the citizens who came here. I mean, Ms. Loretta's 98 years old, and she can speak better to it. I get the rules, and I appreciate them. I do. But as it stands, he bought the house for $155,000. We had 2 houses that just sold on our block for $420,000 without any change to any part of the house. Not making it bigger, not making it smaller. And quite frankly, we've talked about it. If he wants to put a balcony if he wants to put a rooftop deck, knock your socks off. You can't see anything from where we live because all you'll see is other rooftop decks. But this is about maintaining a quality of life for the other neighbors. And quite frankly, more than that, one neighbor's desires and wishes shouldn't overrule every other neighbor on that block. I think you have a bigger responsibility to that. I'm going to let Loretta talk. Loretta, go ahead.
Yeah, I've been there 69 years, and I think if he puts an addition in the backyard, it's going to ruin the appearance of the whole block, in the middle of the block, and it's going to fence me in. And that I don't want.
Keith, do you want to say something? Are you done? Are you okay?
Yeah.
All right. This is Keith Henry. He lives at 717.
Hello, Council. My name is Keith Henry. I live at 717, and we've spoken several times about this addition, and nobody wants it. The Brewers Hill Association doesn't want it. Nobody wants this, and I don't understand how a developer can come in, build what they want, and then leave. I've been there for 8 years. She's been there since 1940. What, Loretta?
1948.
Yeah. My daughter was born in 45. She was 3 years old in March.
Most of
when I
these-
bought the house.
Most of these people have beautiful yards. This is going to be blocking their sunlight. It's going to be blocking their air. We're not going to be able to see each other, talk to each other.
Or look out for each other.
Many nights, most of us have keys. Most of us have keys to each other's houses. I mean, this is going to completely divide the block in half, right down the center.
It will irreparably harm this neighborhood. A neighborhood that's been in the same form and function since 1929. If you allow this today, you will irreparably harm it going forward. And this man standing over here, he won't be here in 3 months, but we will.
Right. Right.
We shovel each other's walks. I mean, this is a neighborhood, and what, $100,000 is going to sway? I mean, it's in the rules, but you're going to destroy our block. Why?
Ma'am?
Hi, Jennifer Sherholtz. I'm at 713 Grundy Street. I'm three houses down from the property. And also, I mean, I agree with everything they've been saying, but also it'll set a precedent for if another house on our block gets sold and a contractor comes in and could build it. And there is a picture in the booklet of it could create this like canyon effect.
It's on page, I'm sorry to interrupt. It's
Sorry,
on
yeah.
page 17, I believe.
But if an addition on one side of one property and the other side, then you're basically blocked in. There's no light coming into the back of your house.
It's page 16, I'm sorry.
So I just don't want it to set a precedent for this happening on other properties on the block.
I'd like to also add, twice before, we've been in front of the BMZA with the same issue, and twice before, the BMZA has unanimously agreed with us.
Thought I recognized you.
There you go, it's the only reason I'm here. I just think this is about, I would just want to say, I don't think that Mr. Sikora is a bad person. I certainly wouldn't have agreed with how you went about this. He went to Mr. Veal without talking to any of us first, so we were surprised when we learned about the administrative variance, and that was upsetting. The issue about this is protecting this neighborhood. And what you're talking about here is he might make $50,000, maybe $70,000, $75,000 more, but you will destroy a neighborhood. Over $70,000. And if you bought the house for $155,000 and you put $100,000 into it, that pushes it up to about $255,000. If you sell it for $385,000, you're still going to make $135,000. What's enough? And I think part of your role here is to protect the citizenry of this city, and I do.
May I respond to some of this? Again, I'll be very brief. First of all, I think it's a little bit unfair to presuppose about Mr. Sakura's business and what he's going to make, which is entirely irrelevant to this. If we were seeking a variance, that would be a different picture. Very quickly, they said that every house on the end of this block is uniform. That's not correct. 739 Grundy Street was granted a 20-foot variance about 10 years ago. The other cases that he talked about being turned down, again, were seeking variances. We're not seeking a variance here. This was a referral from the zoning administrator for an expansion to a non-complying row house. The section that makes it non-complying, the 16-foot dwelling width, is going away under Transform Baltimore. The city has realized that this is creating more sort of administrative tasks for people who lawfully want to expand it, which is what this is complying with all of the regulations of the zoning code. And just a little bit of, I think, exaggeration that this will destroy the neighborhood. I myself have probably worked on a half a dozen additions in Brewers Hill. And, some of them may have a more adverse impact than the other, but it seems to me that the neighbors have more of a problem with the bulk regulations in the R8 zoning district more so than what Mr. Secure does. I would suggest maybe they talk to their councilman to try and, have a legislative fix to the code. But he's doing everything the way he can, and actually a lot less than what he's able to do. And I think he took that into consideration when considering his neighbors.
In response, if you look at page 16, you will see 739. 739 is the structure that's on the left. 739 was built, this was the permit office told me, they didn't get an official permit for that, but because it was built, we weren't able to tear it down. They're like, it's already built, you can't do anything about it. But if you look at this, look at 737 next to it. And if you'll see, 737, nothing ever grows on their porch. You can't, when it snows, their snow never, ever, ever goes away. And if you look at page 17, this is from the same window at 737 and the same window in my house next to Keith's house at 715. Look at the difference in your access to quality of life there. Now, I appreciate what you're saying, but he's never lived there. All of these people have sat here for about 4 hours because they're passionate about it. The 30 people who signed our petition signed it because they're passionate about it. The only 2 Brewers Hill groups there are wrote a letter, and I encourage you all, when you have time, to read it. I mean, we're not doing this because we're concerned about a variance or we're not getting on board with the city. I've lived here 20 years. I've been on board with the city for a long time. She's been on board with the city for a long time. All of us have about 60, 80 years. We're on board here. The reason we're here is because we want to protect it. And we don't want to just protect it for us. We want to protect it for the future. And also, we just became a historic district, as you all might know. I mean, so our property will become even more important if we don't mess with it, if we keep the essential ingredients of how they constructed it. And down the future, it'll become even more important. I think I think it's an important case. And it's all about like $50,000. I swear to God, if I had the money, I'd pay him. I'd buy the house and do it myself.
He might be willing.
Well, I don't have the money. I work for the city. But I think what it is it's, they want, Mr. Sikora wants to make more money, and while I appreciate that, I do, but I think if you leave the regular floor plan and you just fix the house, there's proof in this neighborhood that houses have sold for $420, $400. We have a house for sale for $810. I think you'll get a profit worth your time. And I would encourage you.
Direct your
Oh, sorry.
But I mean,
Well,
I think at this point, folks, it's kind of been talked to death.
Okay.
So I think that we understand what the arguments are from the various parties and what the interests are at play. But thank you all.
Thank you.
Certainly, thank you for your.
Thank you for your time.
Thank you. Okay. 2017-75, 1821 through 1831 West Lafayette Avenue, Tammy Moore.
Ma'am, you make sure they get home okay.
Where are we at, 75?
Okay.
Hello, Council.
All right, you're Ms. Moore?
Yes, I am. How are you?
All right. Ma'am, we have this as a application to use the premises as a convenience store and pizza shop. Is that correct?
A franchise. So it's just not a pizza shop. It's going to be a franchise.
Franchise that
Franchise
sells
pizza shop. Pizza Bowlies.
Okay. Okay. But pizza shop.
Right.
All right. If all those intending to give testimony can raise their right hands and be sworn, please.
Raise your right hands. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Do we have staff reports?
Yes, we have a letter from the Fulton Community Association, the Sandtown Winchester Condo Association, and Inez Robb oppose the zoning of 1821 West Lafayette as a convenience store pizza shop for the following reasons. 1, the gas station across the street is also a convenience store. 2, the hardware store across the street sells convenience products. 3, 1 block away, there are 2 convenience deli stores at Mosher Street and Monroe. 4, at Riggs Avenue and Monroe Street is a convenience deli fast food carryout. 5, the community expressed that they do not want or need another convenience store. 6, On the corners of Lafayette and Monroe Street, young people hang out 24/7. 7 people have been shot and killed in this area. 8, this is a high-crime area. See the police report. 9, the Sandtown Winchester condos are across the street from 1821 Lafayette. 10, this is not zoned for a convenience pizza per the Harlan Park Urban Renewal Plan. Thank you, Inez Robb, President of the Fulton Community Association and Sandtown Winchester Condo Association. And then we have planning's report.
Thank you. Planning Department reviewed this application, noted a couple of things. This property is located in the Harlem Park 2 Urban Renewal Plan area. This particular urban renewal plan has a provision which indicates that, specifically quoting from the plan, current uses classified as non-conforming by zoning enforcement shall abide by the existing regulations listed under this section. The non-conforming use shall not be changed to any use except those permitted within the R8 zoning district of the project area specified above. On that basis, the previous use of the property as a non-conforming laundrette should not be changed to any other use. The second issue is that this property is also in an R8 zoning district, and a carry-out food shop, which would be part of the Pizza Boli's operation, I can imagine, is something which is not a B1 listed use. It is a B2 listed use, and therefore would not be eligible for a change of non-conforming use, even if the urban renewal plan did permit it. The Department of Planning therefore recommends disapproval of this appeal because the urban renewal plan does not allow this non-conforming use that may exist on this property to be changed to the proposed use in an R8 zoning district. Thank you.
Okay. All right. Ma'am, first of all, you understood the recommendation by the Planning Department?
Yes.
Okay. Why don't you tell us about what's intended for the property, and if you can also tell us what, if anything, is currently located at the property.
What is currently anticipated for the property, he wants to do a convenience store and a Pizza Boli's inside that location. Currently, the property is vacant. It's been vacant for over 5 years. He bought it about 2.5 years ago with the intention to open up a Pizza Boli's and a convenience store, but he's been getting a lot of resistance from the neighborhood. So he decided, after some long thinking, that he wants to try to do an appeal in front of the board because he thinks it's important to economically bring a Pizza Boli's into that neighborhood, in addition to a convenience store where the prices will be a little bit more competitive for the neighborhood when it comes to a convenience store.
Okay. So I think we've got.
Can I give you some?
Sure.
Sure. Okay. Here's a letter from the owner, Mr. Khan, expressing his interest in that property. He's owned it, like I said, for about 2.5 years, so he's been paying the taxes on it and the water bill. In addition to a letter from Pizza Boli's. And currently, Pizza Boli's has about 4 locations in the city. They really want to invest in this neighborhood as well. And he believes that it'll be a great economic development project for this neighborhood. We understand that it's in the Harlem Park Renewal Zone, which has been enacted since 1960 and has been revised about 6 or 7 times. We've kind of do some surveillance in the neighborhood, and there's not much going on with this renewal plan. As the gentleman stated, there is a lot of crime going on. So why would you want to keep a building vacant to keep the criminals? I mean, because right now I can show you pictures where they just kind of using it to store their cars. You all can take a picture if you want. If you want it.
Seen this photo, but
right. So they're using it to kind of store cars and do some illegal activity there. But if the property is no longer vacant, that gives the opportunity for that not to happen.
And I certainly do appreciate that point that you brought out. And I think that the city would want there to be productive uses made of property. One thing that you had said, though, is going to bear on what uses are available. The property had formerly been used, I guess it's a commercial property. It's in an R8 district, and has been I guess there's a history of non-conforming use, but you said that the property has been vacant for 5 years. That poses a problem because once the non-conforming use is abandoned or is discontinued for longer than 12 months, though the board has the power to extend that by a period of no longer than, I think, another 12 months. So that would be at most 2 years, and here it's been vacant for 5. So the ability to utilize that non-conforming use history is gone, and at that point, the property, the only thing that, the only uses that may be made of the property are those which conform to the uses, the permitted uses within the R8 zoning district. And here, convenience stores and pizza shops are not permitted, not listed as a permitted or conditional use in the R8 zoning district. So the board wouldn't have the authority to grant the request in this case for what you're seeking to operate here at this property. It's in addition to the points regarding the urban renewal ordinance, which the planning department had brought up, and the ability to change from one non-conforming use to another. So there's kind of multiple layers of problems which make this board without the power to, or deprive this board of the power to grant you the relief that you're seeking.
Okay, so in 2015, he appealed
One
it.
thing that I would point out to you, however,
Sure.
is that the zoning code will be changing. And so the rules which apply currently may not apply prospectively. And I don't know if you have investigated that or not, but if you have not, it might be beneficial for you to either postpone or withdraw this appeal so that you can revisit what potential uses you may be able to make of the property under the new zoning code, which is due to come into effect in June.
In June. Okay, we'll do that.
Okay, so you are postponing or withdrawing
We'll
your case?
postpone.
Okay. Okay, 2017-75, 1821 through 31 West Lafayette Avenue is postponed.
Thank you so much.
All right, thank you. Thank you. Yes. Yeah, if I was going to say that that as there are a number of folks who have appeared in opposition to the request, since the case is being postponed, if you want to be able to participate and be notified of when, if ever, the case comes back in front of the board, so long as you've signed in and we have your information, we will send you out that notice, because the property won't, since it's being postponed, doesn't have to be posted again. But so long as you are, you've signed in, you'll receive notice for whenever the case comes back in front of the board. Okay?
How many postponements do you get?
There's not really a fixed rule on that. So there's not really a direct answer to your question. But the board certainly is mindful of the amount of times a particular case is postponed, and there isn't much tolerance for repeated postponements. All right, thank you all. Thank you. Take care. Make sure that that's the last one we got, right? He was a no Yeah. Yeah, okay, hop down. It's the last one.
I noticed that.
Okay. All right, and we're now calling 2017-72, 1204 North Paris Street. Michael Barb. Mr. Barb.
Good evening, Mr. Chairman. Members of the
Good to
board.
see you again. It's been a while. All right, Mr. Barb, we have this as an application to replace the existing 3-foot fence with a 6-foot fence around the entire premises. Is that correct?
That's correct.
All right, if you can raise your right hand to be sworn, please, sir.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, do you have staff reports?
Planning Department has reviewed this application, notes this property is in the Sandtown-Winchester urban renewal area. The urban renewal plan does not prohibit or further restrict the proposed use and has no objection to the application. Thank you.
All right. Okay, Mr. Barb, why don't you tell us what you're proposing here?
I have an existing 3 to 3.5 foot chain link fence around the entirety of my property, which includes a little bit of what would be considered the front of the property because I'm on an end unit. I am asking for permission for variance to build a higher chain link fence purely for the purposes of safety for my children to play, as well as security, as I've had several attempts successfully to go over my existing fence and steal property out of my yard, namely my lawnmower twice, despite being locked down.
Persistent thieves.
But the thing about the fence is it's very obvious that someone at 3.5 feet can just reach over the fence and pick
grab
up a
items.
child or a dog or whatever and walk away.
Okay. And what kind of fence are you proposing?
Chain link fence. It's not a privacy fence in any matter. Being an end unit, I'm cognizant of the fact that I don't want to create a site issue as far as being able to see oncoming traffic from the other street, being Winchester.
Okay. And going to be any concertina wire atop this tall fence?
No, I'm just hoping that my wife will let me stay on the inside of the fence.
Important consideration. All right. Any other questions? Okay. Thank you very much. All right, and with that, we are off the record with regard to our 3 o'clock docket. All right. Which ones?
2 minutes. Break.
Okay, sure. Build in accordance with whatever the law says, and the incorrect opinion given by a municipal official doesn't waive that requirement, and no rights attached to what is being approved, so.
At what level of court? So that's Montgomery County, but did that get appealed?
That's the other, yeah, that
But that
applies
didn't-
in the state. It was
but
that's
I'm-
an appellate decision arising out of Montgomery
But never,
County.
it never went all the way to like a Supreme Court level or?
I don't know about Supreme Court, but as far as state court, I can't recall if it was a Court of Appeals or Court of Special Appeals opinion, but as far as established law for us, yes.
I think it's an unjust law.
It might be, and like I pointed out, the property owner is not without redress.
Well, but only to the point of the.
There's a
I know
clearly
what party you're
culpable
referring
party.
to, but why isn't the city also a culpable party?
Because
They may be, quite honestly, they may be.
maybe they are. Yes, I was gonna say maybe they are, maybe they aren't. The joy of being the sovereign, I think that actually came up in the Montgomery County case, is that the issue that when you're the sovereign, you get to say when you are and aren't liable for things, so.
Didn't we jump in the boat to get away from the Queen?
Yes, but we took all of her laws with us.
I don't know. I mean, I have a hard time on that point.
I do
but,
too.
But without being philosophical and sticking to the law, I still think it is unique, though.
I kind of
with the
think
size.
what's at play is that the neighbors really want the house to be set back 80 feet. You know,
They
as
might.
far as what theirs is, and it,
They might
and,
want
and, what,
that.
and, what, and there the property is unique because it can't be. You know, because of the forest conservation easement. I don't buy that the value will be partially restored by a 10-foot move.
Well, they don't need to have a basis for their opposition. They don't have a burden.
Yeah, I know. But so.
But I would agree. I question
It is
whether
the
or
only
not it
property
would
on the block
achieve-
with a conservation
Well,
easement,
all
right?
you've
So
got is a
it
couple
does have some
realtors
unique
saying-
characteristics to it that, you know, I don't, in my opinion, I don't think the homeowner is creating the hardship. I think the fact that, you know, it is a smaller lot, it has a conservation easement, it's the only one on the block that has a conservation easement, is a unique, satisfies a uniqueness
That
issue.
may be, again, it has to be the uniqueness that drives the need for the variance. It can't just be like, you know, the property has a forest buffer easement across the back of it, so I can now build I can now exceed the lot coverage that might otherwise apply, just because, I mean, it doesn't really work that way. It's not the cloth that covers all sins. It has to be, the need for the variance has to originate from the uniqueness of the
What
property.
about the fact that it's new construction and the codes have changed? So there are issues about stormwater management that other properties predating that current code weren't subjected to. Doesn't that make it unique?
Well, I think that as far as location of stormwater management, their counsel is correct, that it's not hard and fast as far as where those get located. And there certainly wasn't testimony that there's an inability to locate those anywhere else. There was testimony by way of proffer that they are currently located there and that they would have to be moved or built across if the property was going to be constructed differently, but
Well,
there
but the
wasn't
property would have to be
testimony that-
sloped differently than it was in its raw condition.
Sure, or you could, I mean, I know that there are other ways to mitigate that. I think that the way that the facility is set up is that the runoff would slope towards the area that's covered by the forest buffer easement, but I don't think that that's the only way that you can have stormwater mitigation, but I think that the stormwater mitigation is as much of a red herring as the forest conservation easement, because even with the existing facility, you can separately locate the garage within the space that exists with the forest conservation easement and the existing stormwater management facility.
David,
It's hard because there's only one other property in the area that has a similar square footage. To put a similar footprint of the other
There was only
homes.
one other person who testified, but if you look at the tax map, it shows that there are other properties that have similar dimensions.
David, on the permit issue, so the building permit was not revoked, so that's still in effect.
I guess it is.
My understanding of UNOs, and maybe it's incorrect, my understanding of UNOs is once you complete the building, the UNO inspection and the issuance of a UNO is basically to make sure that it's fit for human habitation. It's that type of issues as opposed to
Well, the
setback.
occupant, the use is another story.
Okay.
But the use is a permitted use. So, you know, we shouldn't be issuing permits for use that's not permitted, but
Okay.
it meets the building code, so they signed off on the occupancy and let them move in. Then they, now, after all these facts came out, they now have revoked that. The only thing, I mean, the code says permit for the use shall be treated the same as a permit for the work under the current code. But it doesn't say a permit for the work. It's treated like a permit for the use. But it was written that way so that we wouldn't be issuing use permits for, to allow for
Take it
work.
Transform's not gonna have any impact on setbacks.
In the new code, that language
In some
is
respects, but I
no
don't think
longer
that
gonna
it
be
would
there.
change the outcome in this case. Yeah.
No, right.
What else is
That,
Yeah, I don't know.
that aspect of this case won't be affected.
It's his right.
No, it wouldn't be that easy.
Do we, when we have 4, is it 3 out of 4?
Yes.
I'm a yes, I'm still a yes.
I'm gonna stay yes.
I am too.
No.
Well, that one's down. Another 25 to go.
All right, 2017-54, the one on Harlem Avenue. We didn't have authority for that one.
Yeah, I'm a no on that.
Grundy. I was a yes on that, he was building to.
Yeah, I'm a yes.
Let's just run through these. 2015-500, 1213 Edmonton Avenue was postponed. 2016-451, 852 South Bond Street was by consent with planning department conditions. 2017-49, 802 South Lakewood Avenue was by consent. 2017-54, 1712 Harlem Avenue. I'm a no.
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 2017-55, 918 South Kenwood Avenue was by consent. 2017-56, 3400 Mueller Street was by consent. 2017-58, 501 North 8th
Mueller
Avenue.
Street was a no-show.
Oh, Mule, that's right, it was. I circled that one. So we'll do that as a no-show. 2017-58, 501 North 8th Avenue was also a no-show. 2017-59, 237 South Conkling Street was by consent. 2017-63, 710 East Eager Street was by consent with planning department conditions. 2017-66, 261 South East Avenue was by consent. 2017-68, 719 Grundy Street, I'm a yes.
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 Agree.
2017-69, 309 South Duncan Street was by consent. 2017-72, 1204 North Paris Street, I'm a no. Emphatic no. Yeah.
Recused.
I'm
a
kidding.
yes.
Yes. I'm a yes.
2017-73, 57-15 Roland Avenue, I'm a no.
Yes.
I'm a yes.
Yes.
2017-75, 1821 through 1831 West Lafayette Avenue. That one was postponed. 2017-76, 820 South Decker Street was by consent. 2017-77, 1920 Gulf Street was by consent. 2017-78, 2521 North Charles Street was by consent. 2017-79, 2100 Alisana was by consent with planning department conditions. 2017-80, 1544 William Street was by consent. 2017-81, 1201 through 1203 East Preston Street was a no-show. 2017-82, 409 South Register Street was by consent. 2017-83, 707 South Glover Street was by consent. 2017-84, 2017-85, 4708 Hartford Road was postponed. 2017-86, 2027 Maryland Avenue was postponed. 2017-88, 612 Springfield Avenue was withdrawn, and 2017-91, 65 and 75 Eastern Avenue by consent with planning department conditions. I gotta go. All right, sorry.
Remind me, when we have 4 people, we need unanimous or 4? Can always never remember those rules.
I think that they need that when it's 4. Is that right, David?
I'm sorry?
When it's 4, they need to have
3 out of 4.
3 out of 4.
Oh,
Yeah.
okay, not yet. It's only when it's 3 that you need unanimous.
3, it's gotta be unanimous, yeah.
Gotcha.
That's why I thought one of you guys would just say abstain and leave me in constant.
Let one of your neighbors object. All right. Okay, we don't have data sheets for the 5 o'clock docket.
Okay, I thought I was the only one that didn't have them.
Okay.
We don't have data sheets for the 5 o'clock docket.
All right.
Here.
Is it Jay's?
Right.
Yeah.
Yeah, that's Jay.
Let's
Marty
see.
doesn't have the 5 o'clock doc.
One,
So we're gonna do a switcheroo.
4.
Oh, you just want the,
At least one will have.
5 o'clock.
Really? In that case.
That's when we talked about
Back here.
maybe it could have just been a letter submitted, I don't know.
yep.
Okay. The only it's not necessarily in any particular order.
The one that had all the debate and all the people.
Now it makes more sense.
Okay.
That was a 3-to-1 vote.
You?
Talking about the Roland Avenue.
Yes.
Yeah.
Yeah, I was the engineer on
So
that
in other
one.
words, the permit gets.
See, I knew this was gonna happen, because I told my wife, I was like, oh yeah, we have a late day today, but we won't be going late like, you know, we did before, so yeah, I won't be home, you
Not
know,
done yet.
sometime between 8 and 9.
I'm sure.
Yeah, yeah. I was like, oh yeah, we'll be home early. Just shut my mouth.
Oh, the vote will go through. There's only 3 of us.
Yeah.
You gonna do the unanimous?
Yeah, yeah. Oh yeah, I need to see if anyone has signed in.
No. Buddy will have to live next to neighbors that don't like him.
Yes. Okay. Ready, Bryce? All right. Good evening. Welcome to our 5 o'clock at 7:30 docket of the Baltimore City Board of Municipal and Zoning Appeals. I guess this is the March 28th, 2017, 5 o'clock at 7:30 convening of the Baltimore City Board of Municipal and Zoning Appeals. A few house rules before we get underway. If you have a cell phone, a pager, anything that plays a ringtone or any other electronically generated sound, plays a chime, etc., we ask at a minimum you please turn those to a vibrate only, if not off position. Similarly, if you need to have a conversation with someone, we ask that you please take that conversation out the double doors to your rear. And the reason for those rules is pretty simple and straightforward. There are a number of microphones which are all arrayed around us up here, and those microphones are all very sensitive, not only for the purpose of amplification, but also for the purpose of recording these proceedings. And cell phones, pagers, and the like, conversations, etc., disrupt not just the general conduct of these proceedings, but also the recording of these proceedings as well. Additionally, those of you who are forward of the wall above you, you can turn around and see that there are 1, 2, 3 video cameras which are mounted on the wall behind you there. And there are 1, 2 video cameras which are mounted on the wall up here behind us. These proceedings are being streamed live on the city's, on the website for the city's cable access network, as well as recorded for broadcast on that cable access network as well, in addition to being saved for later
Posterity.
viewing. Yes, posterity on the city's YouTube channel. Conversations, cell phones, pagers, to the extent anyone still has a pager, going off disrupt that process as well. We'll be voting at the end of the day, and you're, of course, more than welcome to hang around and enjoy a civics lesson if you so choose. But if you have other things to get to on this late March evening, that's certainly understandable, and you can call into the zoning board office in the morning and find out how we ruled in your case. If you take out pen and paper, I'll read the number off for the zoning board office a couple of times. That number is 410-396-4301. Again, that number is 410-396-4301. You will, however, need to wait until you receive the formal written notice of the outcome of your case, which should be forthcoming in about 3 to 4 weeks, before you'll be able to get your permit. We certainly ask that you not build in the city of Baltimore without first obtaining all proper permits. If you haven't already done so, if you are here in opposition to any case today, we ask that you please sign in our sign-in sheet, which is being held up now by Mr. French. The sign-in sheet allows us not only to know generally which cases have opposition, but also allows us to know who needs to receive those aforementioned written notices I just spoke about. In addition, if any case is postponed or for any reason is not heard today, we need to know who you are and how to contact you to let you know when those cases will be going forward. And that's something that we can't do unless we have your contact information. The procedure for our cases today is the same as it is for our cases on any other day. When your case is called, we ask that you please come forward. You'll stand to our left. The opposition, if any, will stand to our right. Once you're all up here, we'll get you sworn in, and then first the appellant will be given the opportunity to present their case, present any documents, testimony, etc., that they would like to offer in support of their positions, respond to any questions which the board may have. Once they have concluded with their presentation, we'll then turn to the opposition, if any, who'll be given the opportunity to present their side of things. Once the opposition is concluded, we'll then return back to the appellant, who will be given the opportunity to respond to any points brought up by their opposition, and to offer a closing statement. We won't be going back and forth, unnecessarily delaying things any longer than is necessary. We'll be hearing the cases on our docket in the order in which they generally appear after we first dispense with some preliminary issues. First, we have, we don't have any postponements, but you will note that there are 3 board members, and the board normally is constituted with 5 members. And while the board can hear cases where all of the parties agree to proceed with only 3 board members, there are a couple of important things to bear in mind, that when the board has 5 members who are sitting, the necessary margin that a applicant needs to attain in order to have a positive outcome is a vote of 3-2. Once the board only has 3 members, you need to have a unanimous vote of all of the members in order for that measure to pass. So if you are the appellant in any case, you can certainly proceed with board members. Just know that your burden is to have unanimous approval of the board as opposed to some voting yes and some voting no. In addition, parties may be able to raise a procedural argument as to whether or not the board is fully constituted in order to constitute a quorum. Whether or not that issue would prevail remains to be seen, but it is a potential issue which may be brought up if there's a contested case. So again, if the parties are in agreement to proceed with 3 board members, then there's really no issue. It's only the case where there is a disagreement amongst the parties that there is an issue there. And with that, we'll next turn to the first group of cases which we'll hear today, which are those which we are hearing on a consent basis. Now, I'm going to call the consent cases together as a group, and the first person will line up here, and everyone else will line up in a row down behind them. Once you're all up here, we'll get you sworn in as a group, and then we'll call each case in turn, and you'll be given the opportunity at that point to offer any information that you would like to have added to the record at that time. First case on our consent agenda is 2017-48, 821 South Linwood Avenue, Rick Vornador. And next would be 2017-50, 829 South Elwood Avenue, also Rick Vornador.
Yes, sir.
Following that will be 2017-52, 19 North Milton Avenue, Julie Tice. You can come a little bit closer right there. There you go. And then 2017-89, 400 to 406 South Dean Street, Nate Prettle. And finally, 2017-92, 24 East Madison Street, Andre Mazelin. All right. If all those intending to give testimony can raise the right hands and be sworn, please.
You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. First case on the consent agenda is 2017-48, 821 South Linwood Avenue, Rick Vornador.
Yes, I'm here on his behalf. I'm his son and partner, Philip Vornador.
Okay, Mr. Vornador, we have this as an application to construct second floor overhanging rear addition and rooftop deck at this location. Is that correct?
Yes, sir.
Okay. You can come a little bit closer to the microphones there. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Thank you very much. And Mr. Vornador, was there anything you wanted to offer to supplement the record in this case?
No, sir.
All right. Zoning Board staff, having previously reviewed your application, we've determined that there is sufficient information to approve your appeal. Calling the next case, which is 2017-50, 829 South Elwood Avenue, which is also Rick Vornador, and Philip Vornador, I will imagine, is appearing for that case as well.
Yes, sir.
All right, and Mr. Vornador, we have that case as an application to construct a 2-story side and second floor rear overhanging addition and rooftop deck at this location. Is that correct?
Yes, sir.
All right. Mr. French, anything with respect to this appeal?
Planning Department has no comment on this application. Thank you.
Okay. And Mr. Vornador, anything you would like to offer to supplement the record in your case?
No, just I appreciate your time.
Thank you. All right, the zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve the appeal. Have a good evening.
Thank you.
Next, 2017-52, 19 North Milton Avenue, Julie Tice.
Hello.
Afternoon. Well, evening, I guess. Ms. Tice, we have this application to construct a second floor rear addition and rooftop deck at this location. Is that correct?
That is correct.
Mr. French, anything for the planning department with respect to this case?
Planning Department has no comment on this application. Thank you.
All right. And Ms. Tice, anything you would like to offer to supplement the record in your case?
Nope.
All right. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve the appeal.
Thanks, and I might make it home before my baby's bedtime.
There you go. That makes one of us. 2017-89, 400 to 406 South Dean Street, Nate Prettle.
Good evening.
Afternoon, Mr. Rowell. Good evening, Mr. Prettle. We have this as an application to consolidate lots, construct a 2-story garage and a mezzanine office at this location. Is that correct?
That is correct.
All right. Mr. French, what say you for the planning department?
Planning Department has no comment on this application. Thank you.
Okay, and Mr. Prettle, was there anything you'd like to offer to supplement the record in this case?
Just add that you do have a support letter from the Highlandtown Community Association, and the mezzanine office is just, it's a 2-story garage without a second floor. It's just a small stair office for a new company that's opening in Highlandtown.
That was gonna be my question.
Yep.
Some conditions.
Yes, and we're amenable to, it's about lighting. It's on an alley street.
Cameras and lighting.
Yeah, an alley street that doesn't get a lot of light, and the community is concerned about safety, and my client's more than willing to install those safety measures.
Okay, so you're agreeing to the conditions that are reflected in the letter from the community?
Yes.
All right. Anything else? Okay. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve the appeal.
Great, thank you.
Take care. Have a good evening.
You too.
Next, 2017-92, 24 East Madison Street, Andre Maisler.
Good evening.
Good evening, sir. We have this as an application to add outdoor table service to a coffee shop and restaurant. Is that correct?
Yes.
All right. Mr. French, anything for the planning department?
Yes, thank you. Planning Department reviewed this application, noted this property is located in the Mount Vernon Historic District. This particular proposed use is not inconsistent with the purposes and intent of that historic district. The department recommends approval of this appeal, subject to these conditions. A minimum of 9 feet of the sidewalk along St. Paul Street must remain clear and unobstructed for pedestrian use. This larger figure is being requested because this particular area also hosts a fairly busy bus stop. Secondly, the capacity of the outdoor seating area will be not more than 8 tables and 28 patrons, basically according to the design submitted by the applicant. The tables will be limited to those that can seat 2 or 4 patrons and are to be kept against the wall of the building. There will be no outdoor bar, no outdoor music, jukebox, or other form of entertainment, and all patrons must be seated for dining and served by waitstaff. Thank you.
Thank you. And Mr. Maisel, are those conditions stated by the planning department acceptable to you?
Yes.
Okay. And I understand that there are some community association conditions as well?
Yes.
You have that in the record?
Received a letter from the community association in June, and I think that kind of reduced the number of tables.
Yes, I've modified the amount of tables that are outside and where they're located.
Okay.
From the original plan, we've pulled them from the rear yard, side yard on property.
Their concern was.
All right, so this is a revised drawing?
Yes, it is.
You can have that one back. Okay, so the letter that we have from the community association reflects the agreement between you and they?
Yes, it does.
Okay. And I can't recall if I already asked this or not, but you're amenable to conditions offered by the planning department as well?
I am.
Okay. Anything further you would like to add to supplement the record in your case?
No, sir.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve the appeal.
Thank you.
Take care. Good luck. All right. Next, the remainder of our docket will include cases where opposition has signed in, and frequently we found that opposition is a result of either a lack of communication or miscommunication amongst the parties. And it can be useful to offer the parties an opportunity to have a dialogue between the two of them to see if they can resolve whatever differences they may have. Obviously, if there are 2 parties in a dispute and the parties ask the board to resolve the dispute, one of those 2 parties is bound to go away disappointed with the result. So this is your opportunity to avoid that unhappy fate. I'm going to call out the cases, or I guess case where there's been opposition which is signed in, and ask if there has been any dialogue between the parties, or if the parties desire an opportunity to have a dialogue, or continue to have a dialogue now to see if they can resolve their differences. It's certainly not an obligation to accept the opportunity to speak with the other side about a resolution, but that is certainly encouraged and appreciated where it is taken. The case where we have opposition which is signed in is 2017-74, 3700 Fernhill Avenue. And have you folks spoken about a resolution, or?
We have talked to dialogue prior to the letter being submitted.
Okay.
To the association.
All right, and would you all like to have a dialogue now, see if you can get something worked out, or is everyone committed to just having a hearing on it?
I'm willing to have dialogue. I've tried to have dialogue. I wanted to, when I spoke to the president, I asked if we could coexist in this venture that I was trying to do.
Well, don't get into the substance of it. Don't get into the substance right now. But, so you said that you would like to have a dialogue. I'm guessing you folks are with the opposition.
Yes.
And so she would like to speak. Would you like to step outside and talk and see what you can get worked out? If you can't get anything worked out, then we just proceed to a hearing. It certainly doesn't cost you anything.
Sure.
Okay. All right. Just let us know when you're ready to go forward. We only have a handful of cases at this point, so we'll get to you very quickly. 2016-224, 6810 Reisterstown Road, Mohammed Salim.
Good evening, Your Honor.
Good evening.
Francis Borgerding Jr. on behalf of the property owner.
Okay, that last name, sir?
Borgerding, B-O-R-G-E-R-D-I-N-G.
Frank?
Yes.
E-O-R.
G-E-R-D-I-N-G.
All right. And we have this as an application to add carry-out to existing gas station and convenience stores. Is that correct?
Correct.
All right. If all those intending to give testimony can raise their right hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Do we have staff reports?
Yes, we have a letter from the Falls Staff Improvement Association received this morning. They write that the need for such an establishment, given that there are 4 existing carryout establishments within 2 blocks of the gas station that sell fried chicken. This does not include similar establishments within the Reisterstown Road Plaza, which is also within 2 blocks of the gas station. Residents were concerned about the possibility of increased traffic jams and accidents as drivers cut through the gas station to get to other areas in the community, and that they would add on by those getting gas and chicken. Others concerned about loitering around the station. They say that in light of these concerns, the association is not in favor of having another business as described above operating in the Falstaff neighborhood. Several single-family homes are located very close in the immediate vicinity of where the gas station is located, and the increasing types of this business is not consistent with our overall vision for our neighborhood and will potentially diminish the property values of surrounding homes. The association requests that the board not approve this item. And then we have planning's report.
Thank you. Planning Department reviewed this application, noted this property is in the Reisterstown Plaza Transit Station urban renewal area, which urban renewal plan does not prohibit or further restrict this proposed use. This is a proposal to modify a conditional use by adding a permitted use. The department has no objection to the application. Thank you.
Thank you. All right, sir?
Yes, I have with me today Mr. Bruce Doak, who's my land use expert, as well as one of the owners of the property, and Mr. Mohammed Salam, and I would like to proffer their testimony. I don't know if you'd like to have them testify or you just accept proffer. Okay.
Proffer is fine.
As far as a proffer, Mr. Doak would testify if he did testify that the conditional use meets the findings of 14204 of the zoning regulations, as well as the considerations called for in section 14205 of the zoning regulations. Mr. Doak also submitted a parking plan, which you should have a copy of. That parking plan indicates that the parking requirements are met with regard to this use. I would say that if he called to testify, he would say that he does not feel that the use would cause a traffic problem or accidents, et cetera, as listed in the community's letter. As far as loitering, I'll address the issue that they raise in their letter of loitering. There is a no loitering sign and the owner would call the police if someone did loiter, but short of that, I don't know what, he could do as far as anyone loitering there. Here's a picture, for your honors, of the counter, which is going to be used for fried chicken. That's in the convenience store that's already operating there. So it's just a counter where fried chicken not to order, but to go. So if someone's in there and they're getting gas, they want to grab a piece of chicken, they can do that. That's the concept.
Okay. All right. Any questions? All right. Thank you all.
Thank you so
Good luck.
much.
Next, 2017-53, 912 Stoll Street, Patricia Lee. I'm calling again 2017-53, 912 Stoll Street, Patricia Lee. And 2017-95, 7108 Harford Road, Imandra Navarro. Good evening, ma'am. You're Ms. Navarro?
Yes.
Okay. And ma'am, we have this in application to use the premises as 2 dwelling units. Is that correct?
Yes.
All right. If all those intending to give testimony can raise their right hands and be sworn, please.
Swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
All right. Do we have staff reports?
Yes, we have letters from the Harbell Community Association and the North Harford Road Community Association. They write that the property in question is within the boundaries of the North Harford Road Community Association, a community predominantly composed of well-kept, owner-occupied single-family dwellings. The association finds that there are sufficient rental units within their boundaries to meet the current market, and an increase in rental units within the community would decrease nearby property values. They note that this property is within a section of Harford Road where renters tend to be transient as units frequently turn over. They feel an increase in rental units in that area would serve to denigrate the surrounding community. They note that only the first floor of this property has access to the alley in the rear of the dwelling, and feel that as this would lead second-floor residents to dispose of their waste in already overburdened street containers. They note the abuse of street containers has resulted in the city removing containers from Harford Road. Harbell supports the North Harford Road Community Association in their opposition to this appeal, and we feel we would ask the board to deny the appeal. And then we have planning's report.
Thank you. Planning Department reviewed this application, noted that it meets the requirements for lot area for conversion to a multifamily dwelling. The department also notes that the property is not able to provide the off-street parking, as there is neither a sufficient space in the rear yard for a parking pad, and the fact that the rear alley is only 10 feet wide and does not meet the zoning code requirement for access. However, the board could grant a variance of 75% of the required off-street parking. On the basis of those reviews, the department has no objection to the application. Thank you.
Thank you. All right. Ms. Navarro, why don't you tell us what you are planning to do with the property here?
Yeah, my son translated for me, for I don't speak Spanish. I speak
Okay.
Spanish.
I'm gonna translate for her because her English is.
I understand, but I don't
She
speak.
can't speak it, but she understands a lot.
Okay, all right. There's a separate oath that we have to administer for translators. So if you can raise your right hand, please.
I have the translator oath on me.
Sure.
It doesn't really work for. Do you swear or affirm that you will translate this hearing accordingly, to the best of your knowledge?
Swear.
Okay.
Okay.
Something like that.
It's close. All right. If you can have her say what her plans are for the property, what she's looking to make this change, and then, well, I guess start off with that, and then we'll go from there.
She's saying that she bought the house as it is right now in 2014. She hasn't changed anything. When we went to sell the property and the appraiser said the house is being used illegally, the property is being used as a one dwelling. The house has been used as a one dwelling since we bought the property. We called the zoning and they said the property is listed as a furniture store.
Yo compré la casa con two dwelling.
She bought the property as a two dwelling unit, not as a furniture store.
Okay, yeah, we have it that the last authorized use was for a one dwelling unit and then a secondhand store. So she just wants the two dwelling units,
Yeah.
not one dwelling unit with a.
There is no longer a furniture store in the property. She called asking just for the two dwelling units.
Okay.
Y anteriormente fue two dwelling.
And before, and
I see the car for zoning.
the zoning card in 1962, the house was a two dwelling unit, and in 1998, the house was changed to a furniture store.
Yeah, I think we've got some record of that.
And I have a picture of it if
I have the
you
picture
need
for
it,
the zoning card.
if you would like
So
to
there's
see.
not going to be any other commercial use made of that other unit once.
Yeah,
once the
that
property's
unit's not
converted?
gonna be used for nothing.
Okay. This is the floor plan?
Yes.
The problem, in the front, I no put
The front, la parte
You
delante.
might want to use your translator.
¿Por qué no pusiste la parte delante de la casa?
la
Patio.
yarda de
She
adelante.
didn't put the yard of the front of the house.
Okay.
La muchacha de zoning me dijo que son buenos.
The lady from the zoning said that it didn't matter.
Yeah, I was going to say that she wouldn't needed to have done that, just to have a drawing of the floor plan within the house, not so much the lawn and all that stuff. Questions?
Nope.
Thank you.
Thank you.
Thank you.
¿Cómo es la respuesta?
Derek, can you go see where they are?
We're working on parking. They want 3 more minutes.
Okay. Good. Okay. We'll go off the record. Want to just deliberate?
Yeah, I agree.
Okay. All right. Anyone wants to talk about?
The last one, Crawford Road.
Okay.
I'm okay with it, but she needs, is she asking for a parking variance also?
No. I think that under transform,
Oh, yeah, I'm reading transforms.
Yeah.
Right.
yeah, they weren't cited for parking with respect to this one, which might also have something to do with why they're going forward with their appeal now instead of.
Yeah, because you would need it in June.
That's right.
Which case was that? I'm sorry.
The
Hartford
last
Road.
Hartford Road.
Yeah, I almost jumped to that same one and was like, oh yeah, that's right, doesn't need it.
Okay, I'm okay with it, yeah.
Yeah, I am too.
Any others?
I'm okay with Reisterstown as well.
Yeah.
Yeah. All right, let's just vote. 2016-224, 6810 Reisterstown Road. I'm a yes.
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 2017-48, 821 South Linwood Avenue was by consent. 2017-50, 829 South Elwood Avenue was by consent. 2017-52, 19 North Lincoln Avenue was by consent. 2017-53, 912 Stoll Street was a no-show. I guess with that one, David, we can follow up and find out.
Yeah,
'Cause I don't know if they showed.
They
and
might
then-
have had to leave early.
Yeah, because we're 2.5 hours after we're supposed to be convening. 2017-89, 400 through 406 South Dean Street was by consent. 2017-92, 24 East Madison Street was by consent with planning department conditions and also incorporating conditions identified in the letter from the Community Association. And 2017-95, 7108 Hartford Road, I'm a yes.
Yes. Agreed.
You're welcome, good luck.
Yeah,
Good luck to
you may
both of
wanna
you.
let him know. Oh, okay, he knows.
Yeah.
I tried to give him the thumbs up to let him know so he wouldn't continue to
Couldn't
sit
sit there,
here.
yeah. Yeah, that's the worst. And they're like, oh, yeah, I didn't know.
As if you haven't been here long enough today. It's fine.
Probably like one and.
Do we have any issues with this?
Yeah.
Communities are always so up and up. So really confined narrow.
They go to like other court hearings too. I mean, it's my
Enough of these long meetings
my spare.
till Roland Avenue comes back for some reason.
Yes, for some reason.
That's gonna get appealed.
Get remanded back.
No, I don't think it'll be remanded. It might be remanded with instructions.
Right.
Yes, I guess we have, this is the legacy of Jim Craft.
Yes. I tried to get him to, and I still haven't given up to amend the new code to allow the board to have their own schedule back, according to their rules. But we'll see how it goes.
You're running out of time, that's the problem.
We'll
If
have-
you're gonna try to do it before June.
No, it's gonna need a separate amendment.
Yeah.
So probably not on the, if it's not already in there, it's not gonna make the schedule probably.
They tried to make it worse. I did stop that anyway.
Starting at 7?
No, they wanted, well, they wanted the board to require 30-day posting
Hey,
for conditional uses.
we got one more
21
hearing to
days
discuss
for
in the hallway, so.
variances. And I said, it's ridiculous.
Ridiculous.
Yeah, just a few more minutes. They'll be back in.
Well, and the longer posting period for the issue with the lower threshold?
Yeah.
Time to gather opposition for the stores and whatnot, and they wanted to make it 30 days so that there was enough time for community That wasn't surprising. Okay, so how are we looking, folks? Yes. Sorry.
Okay, off the record, I think that we're fine, that we have come to.
Yes, we've come to.
Okay, you got something worked out? That's great. It's always good when people are able to sit down and talk and work out differences. So, all right, back on the record, and we'll call 2017-74, 3700 Fernhill Avenue. Stephanie Williams. You're Ms. Williams?
Yes, I am.
All right, and Ms. Williams, we have this application to use the premises as a 20-child daycare center. Is that correct?
That's correct.
All right, if all those intending to give testimony can raise their right hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and do we have staff reports?
Well, I'll ask, Ms. Rice?
Yes.
Yes. Does this in any way change what you've written in the letter?
No, it doesn't change anything
Okay.
of what our concerns are.
That's okay, we'll go with it. The Board of Directors of Garrison Hill Community Association has decided it is not in our favor to create a daycare center within our residential community and opposes the proposed zoning change to the above-mentioned property. For more than 30 years, the property owners and residents of Garrison Hill have diligently strived to maintain the attractive homes and apartments, quiet streets, and low crime activity within our community. While we understand that such qualities serve as desirable conditions for the rearing of our youth, our community already has 2 child daycare facilities that have been in business for several years, which also serves our residents. In addition, regardless of the amount of resources allocated towards the safeguard of the property, the presence of an uninhabited center in our community poses as a target for loitering, vandalism, and burglary, a safety concern that would endanger your immediate neighbors and the local residents. Next, we have planning's report.
Thank you. Planning Department reviewed this application, noted that this property is located on a fairly narrow street, Fernhill Avenue, with modest capacities for vehicles, and noted that due to the potential impact of serving 20 children on site, there is a need for a suitable drop-off or pickup location. And this could be provided in one of 2 ways. The way across the property would be to provide some type of a driveway loop that would link from Fernhill Avenue to the 20-foot wide alley in the rear of the property, creating a drop-off or pickup location on-site. The alternative is for the applicant to request consideration of a passenger loading zone to be established on Fernhill Avenue. The department therefore recommends approval of this application, if granted, be subject to the condition that the applicant requests approval of a passenger loading zone in front of the property be granted by the Department of Transportation and the Parking Authority of Baltimore City, or alternatively provides the passenger loading zone on site. Thank you.
All right, Ms. Williams, I guess first, are the conditions identified by the planning department acceptable to you?
Yes.
Okay, all right, and so you folks had a discussion off the record to try to resolve
Yes, sir.
your issues, and you've made us aware that you've come to a resolution. So why don't you tell us what that is, and then we can go forward from there.
One being of security, of course, as noted in the first part of the letter. Then having a daycare center, standalone daycare center, was of issue or concern when after hours, Ms. Williams and other staff would not have been around. Ms. Williams has given us an assurance that there is an inhabitant actually, in fact, currently at the property and will remain there in terms of security or maintaining the household or the property, should I say. Second was the parking issue, which is also already been an issue, being that there is another R4 right across the street, that being Callaway Elementary, and also the Boys and Girls Club, which is adjoined to Callaway Elementary, That has been an ongoing issue for residents that have to access Callaway Avenue, their homes on Callaway as well as Dolefield and Fern Hill. The 3700 block of Fern Hill is a one-way, which has already had some issues with traffic. So we have worked out that I've been told by Ms. Williams that the loading zone would be for anybody, any drop-off, that being for the daycare center and, as well as the school. So we hope that would, we are okay with that resolution.
Okay.
You know something you want to say?
Yes.
If you can, I guess, first, make sure that we grab names.
I'm
but-
sorry. I'm Taiwan Rice. I'm the president of Garrison Hill Community Association, and my address is 3805 Fern Hill Avenue.
Okay. And ma'am?
My
your
name
and
is
address.
Klondike Potts, and I'm the vice president of Garrison Hill Community Association Incorporated. My address is 3811 Fern Hill Avenue. The concern, the loading zone. It's a residential area, and Ms. Williams said the loading zone would be for anyone. Not familiar with loading zones, but never had a loading zone in that residential area. Also, my next concern when we were talking to Ms. Williams out there, she did make the statement that it was 20 kids, but she said, which was very kind of her, to reach out to the community association. The statement was made that if she had had a lesser number of kids, I think you said 8 or less, I'm not sure, that she would not have had to reach out to the community association. My concern, I've been in, I call it home since 54 years. I'm 68. It was my parents' home. Of course, they got sick, passed. I wound up with the house, so that's been home for me. My concern is the residential area. I would love to keep it so, and my concern was when the notice that was posted, I seen zoning, and then when Mr. Rice reached out to Ms. Williams and they talked, there's the zoning issue. I didn't want anything that had to change any zoning, because it's an ongoing, I'm gonna say ongoing fight to keep the community as is, a residential community, not saying with all of the other negative elements that go on. I suggested to Ms. Williams in the future, before you purchase a building, and she's gonna have children there. There's the Dofield Apartments, this is 3700, then right across, there's the dumpster for Dofield Apartments. The apartments have been a headache. We've been dealing with the management and everything. There's been killings, there's been the drugs, there's just so much negative activity. And I'm like, why would someone, but, she's going on what research she did. I suggested to her, before you buy anything anymore, you talk to the neighbors and you see what's going on. And yes, Callaway Elementary School, George McMectin Boys and Girls Club is there. We had to fight to get the Boys and Girls Club open again. But like she said, that number, changing it from 20 to 8 kids, does that really make a difference? But if you're gonna vote on it, I'm not up with the statutes of when she said 20 kids, and she's saying someone is gonna be living, someone will always be upstairs. But we're looking at just the congestion, that loading zone sign, parking is hectic. I have my own personal driveway, so I don't have to worry about that. I'm in the 3800 block of Fern Hill. But those houses there, they park on the street. And it's the school. And my concern, major concern, like I said, that loading sign and the fact of our little people, our future, and those Dofield apartments that's there. And that's not something I'm just creating. There's police reports. I'll just give you one example. One evening, I'm getting ready to go to work. Go to bed. And my porch, I have it closed in, and I happened to look out, and all I seen, looking down the street, I knew it was people down there, but all I seen was white. So I made a call to a neighbor that lived closer. I made a call to then I called Northwest Police. There was a shooting. It was like something you seen on TV. What had went there, and this is just not just one time. And then the drugs, the weather is changing. Northwest Police Department, they are familiar with it. It's going, a nice neighborhood, but we have two areas within Garrison Hill. And one of them is right there in that Dofield Apartments, and the residents that live right the next street, which is Callaway, I think that's the 4700 block. Then we have the 3700 block where Ms. Williams is with the daycare. My personal opinion, I think if Ms. Williams had came and talked to the neighbors prior to her spending her money, she would not have put a daycare there. Even if she's going to have someone living up on the second story, like she said, and her daycare is on the first floor. The world we live in is very dangerous. And a lot of times we have to make decisions thinking about our future, and I'm talking about little ones. And we got Callaway Elementary School there and the Boys and Girls Club. And it's an ongoing fight to stop some of the craziness in our society. From affecting our community. And I don't want, it's a fight to keep our community not to cave into to be like what I call the Lower Park Heights. And if you've lived in Baltimore a long time, I can remember Park Heights, when I say Lower Park Heights, when it was really nice. And I've seen the changes. And then they moved the boundary lines coming closer to us, Wabash. And it's just a battle to keep your community nice. And when the Boys and Girls Club, when we fought to get that, when the Powell Center gave up. But I recall when the directors came out, they were like, oh, this is a beautiful neighborhood. They looked at the grass and they looked at the lawns and they thinking, yes, it looks nice. But then we got right there where Miss Williams,
No, my business.
3700 Burn.
Yeah.
The Dofield Apartments is the
Right, but I can't control what goes on in the apartments. Crime is everywhere, and the best that I can do is, there is a demand for childcare in the area. Yes, you have 2 daycare centers and you have the Boys and Girls Club, but there still is a demand for childcare in the area. My kids would not be unsupervised running up and down the street. They wouldn't be over in Dofield Apartments. What we would try to do is to create a different environment for them from what they might see or might be used to, and try to create something different for them. So
The thing that occurs to me is that a couple of things. First, to your point as to demand for childcare, I'll say that the board receives frequent requests in cases like this for daycare centers in residential areas, and that really is a testament to the fact that there are a lot of working families in the city, and children and families with children are parts of the fabric of the community, and it's really sort of a sign of vibrancy within the community, and part of the residential fabric of the neighborhood. But the thing that it signifies is that there are as I said, families who are working who need care for their children while they are at work. And so that tells me that there is within the community a large number of people, because you said that there's already 2 daycares, and this would be a third. So there's a large number of folks within the community who are working and who need to have quality child care close to home for their children while they're at work. So I think that is a good thing, because it means that you've got a large number of people in your community who are working and who aren't running around doing negative things. There may be elements within the community who are doing that, but the fact that there sounds like there's a growing demand within the community signifies that there are more people who are working, and therefore there are more people who have a need to have childcare within your community. So that's a positive sign, because it means the community is growing and growing in the right way, with A, families, and B, working families. As far as you brought up the loading zone. Mr. French, you can kind of brush me up here on loading zones, because we haven't touched on them in a while, but I would imagine that the authority for the loading zone would be for certain hours, and that would be space dedicated to the daycare for children to be picked up and dropped off, and that outside of those hours, that space would be open for use by anyone else in the community, but you can.
That's correct. It's the same concept, basically, as you have in front of a church, where they have a designated area for people to be dropped off or picked up at the time of services, for example. The length of the loading zone is determined by the Department of Transportation of Baltimore City and the Parking Authority of Baltimore City. This particular property has over 100 feet of frontage on Fern Hill. The average car length is usually taken at about 20 feet, so that's 5 car lengths of space that exist in front of this property. They could use 3 of those car lengths for a passenger loading zone and still have 2 spaces left for parking on street, for example. Now, how much they'll actually take, they would determine based upon basically the information that the applicant is going to provide them, which is, how many children, what are the hours of operation, the days of operation, when will the drop-off occur, when will the pickup occur. So that'll all be decided by another agency. It won't be decided by the planning department. We're simply saying we recognize that this particular place along Fern Hill could provide a passenger loading zone, but we're not saying it necessarily will. That decision gets made by the Department of Transportation and the Parking Authority.
Okay, now my question is Callaway Elementary School, which the plans are for, I can't think when, they want to make it into, up to the 8th grade eventually. But the teachers park there, during school time, so her loading zone, you said 100 feet, right? Then you
Well, I said it could be. I'm not saying it will be.
Well, the loading zone, now, when school is in session, and if I'm going down to the school for me, I can walk down to school. Forget about it, I have somewhere else to go, and I'm back in my driveway, because the teachers are parking there, and then it's like 4 homes there.
And I would say that will be a factor they will take into account, I can assure you, because they're going to look at what is the total demand for parking in that area, and can they afford to sacrifice some parking spaces for certain times on certain days in order to allow passenger loading. That's how they analyze it.
Right, because I assume your business is Monday through Friday, or?
Yes, it's Monday through Friday. But may I say something? I have been in contact with Department of Transportation, and the representative his name is Stanford Leach, and I spoke with him again last week, and he said that if anyone wanted to contact him from here, you could. I have his name and number, but he basically said that they are not going to put up the loading zone until I'm approved for the zoning for the daycare. They're not going to do that in advance. He also told me that the loading zone is not just for me. It'll be in front of my daycare center, but it's 15 minutes for anybody that parks there, or 50, whatever the time limit is. I do know it's gonna be in effect during the hours probably of operation, and that's negotiable. I mean, if you want it like at 4:30, we could work something out.
Would you consider not having the loading zone?
The planning department is, it's one of the conditions that they're asking for. And the idea being that, there's going to be pickup and drop off of children. And I can speak from experience in my neighborhood, with our school that, when, parking spaces are tight, people double park, and it leads to a lot of congestion and the like. So the thinking, I will imagine anyway, with the requirement for the passenger loading zone is that by having that facility there for the parents, those spaces, then parents, when they come to drop off, they don't all just show up at one time. There's normally a staggered time that people come and they drop off kids and they drop them off and then they get back in their car and they leave. So by providing that space, that's going to allow for the parents to have that dedicated parking space there so that they can pick up and drop off their children, and that's going to be that's going to be a benefit for the community because you're not going to have people double parking, which is going to be the bigger problem. Particularly, I think that someone had observed that that Ferndale is one way at that block. So if the people are double parking and it's a one-way street, it's going to cause a problem. So by having the dedicated passenger loading zone, that's actually going to be a good thing for the community, not a detriment. But what we've got is that you folks worked out an agreement. Sounds like that there's going to be a resident at the property to address concerns about security for parking. There's going to be a requirement of the passenger loading zone. And I think that you mentioned the third thing that I'm not.
No, I didn't mention it.
Oh, okay. So, I think that kind of encompasses what you folks have addressed here, and then we also have the conditions that are being offered by the planning department as well. And as I said before, it's good that you all took the time to sit down with one another and work something out. And B, I really do think that it's a sign of vibrancy of your community that you're having this growing need within your community for daycare, because it means that you have more working families, or you have A, more children, and B, you have more people who are working in your community. So those are always good things, because I think that means that you're in a good, stable neighborhood. And the more that you have of that, the more energy you have in a direction that's more productive than, kind of, it sounds like the encroaching negative elements that might be around the community. So the more vibrancy you have within the community, the more you stave off those negative elements. So it's a good thing for your community. All right, anything further at this point?
No, sir.
All right, thank you all.
Thank you.
Take care. And have a good evening. All right. So 2017-74, 3700 Fernhill Avenue. I'm a yes with the conditions by the planning department, with the additional conditions of that the property is going to be occupied by a resident, and the bit about parking is the part that you had required as well. So
Yes, agreed.
I double jinxed.